Of the film has been stopped by the court below by the impugned order, which I am aggrieved of, my lord.
Where is your notice to the other side that you mentioned today?
My lord, there is no notice, my lord. I am mentioning, if my lord so allows, my lord, I said certainly come back after serving notice.
So
if
did
not
you
before
have
that.
filed any application?
But it is the
filed
appeal for the first time. It is appeal. It is returnable
So
today.
you have to serve the application, no?
But
Who is your other
it
side?
has been served, my lord. Today I am mentioning, if my lord so allows, my lord, I can serve and come back.
No, there was an order towards service.
No, it's for the first time the matter is appearing, but certainly I'll give a notice to the other side. I'll not take the matter as a surprise, my lord. But kindly give me, my lord, give me permission, my lord, I'll serve and come back, my lord.
We don't know. Hand over the slip. Let us see how we are placed.
My lord, I'm deeply obliged.
May I leave to mention
Why
one?
you're mentioning, sir? Thursday is the mentioning day. Yes. Decision করো আগে সাহিত্যে দেখো তারপর বিকেলে চিন্তা করো Yes. You for the petitioner?
But Miss Anjalina has appeared there and I am appearing here.
Yes. I'm
Both-
appearing for the
Both of you are
petitioner.
Both of you for the petitioner.
Yes, Your Lordship.
Which is the order?
The order is, Your Lordship, 6th February 2018.
Page 16.
So, when did you file the contempt?
Your Lordship, immediately, Your Lordship, I have communicated the order on 9th February 2018, Your Lordship, page number 19. And thereafter,
Yes.
thereafter certain process were there, Your Lordship, because the Tehsildar, he came to the spot to demarcate the land, Your Lordship. He did something, but actual demarcation was not done. But he said that I have seen the land, so I will be issuing an appropriate order in respect of this demarcation. But till today we were waiting, but till today no order of demarcation was passed. And in between, Your Lordship knows, there was COVID, Your Lordship. That is the reason why immediately we could not file any application for contempt.
The order notice was issued by them on 21st March 2018.
Yes, Your Lordship. They fixed the date for demarcation. But in fact, Your Lordship, no demarcation was carried out because my land was not shown by them, by him to us. And thereafter, he said that he will be passing an appropriate order. But then, Your Lordship, he did not pass any order. He passed an order in another case. Your Lordship, we have submitted our objections and everything. It is at page number 26. He passed an order in another case. It was in respect of one Kushal Baidia. And stated something about our land. Page number 26, Your Lordship, may kindly come.
Yes.
This is in respect of a complaint of Kushal Baidia. In this complaint, Your Lordship, he has given a report and there he has mentioned about our land, Your Lordship.
What he has said.
He has said, Your Lordship, the report of revenue survey for the reveals a land bearing survey number situated in Lumberline village stands recorded in favor of Matthew Joseph. An area of this out of survey number, this recorded as a part is found under physical occupation of this and is the power of attorney or Lord Matthew Joseph. That's it. I am concerned with my land. This court has ordered that in terms of the record entry which has been issued in my favor, demarcation should be carried out and my land should be shown by him. But nothing happened. Then again, Again, on the complaint of another person, again it was done, page number 27, Your Lordship. 27, and the map is at page number 28.
It includes your land.
Yes, but in another proceeding, he is submitting something else. Actual demarcation in respect of my land has never been done. This is my specific contention, Your Lordship. I have issued the notice to the other side also. Let him come and say that he has actually demarcated my land in terms of my record entry.
No minutes was prepared on the date of the inspection.
No field report, no minutes.
You were present.
I was there, but actual demarcation did not take place. He has not shown me the boundary of my land.
When was your contempt application filed?
It was in 2021, Your Lordship, because process was going on. So I was waiting, and then COVID was there, Your Lordship, for more than 2 years, Your Lordship. So that is the reason why this was filed in.
But Tosildar is the contemner. Ms. Nag has served the notice upon the Tosildar.
And I am appearing, my lordship, representing the Tahsildar.
You're appearing.
Yes,
ma'am.
he's appearing. I have already issued the notice to him.
Yes, what do you say?
My lordship, on 9/5/2018, the demarcation has been done, my lordship.
9th of
9th May 2018, my lordship.
Let them show the field report, Your Lordship. Field report is mandatory in any circumstances. Let them show the field report that really on 9th May 2018, this demarcation was
My
done.
lordship, I will take instruction. I will take that copy, my lordship. I will serve it, my lordship.
the present contempt application has been filed alleging. The present contempt application has been filed alleging violation of an order dated 6th of February 2018. Passed in name. What is the appeal number? Appeal number is MA
MA number 005 of 2018.
passed in an appeal being MA 005 of 2018. Appeal has been disposed of.
Yes, Madam.
Yes,
Madam
Your
has-
Lordship. Appeal disposed of.
Put it appearing for the applicant submits that a copy of the contempt application. You have to send a copy to the Tahsildar also. Let
Already sent. Already sent, Your Lordship. Affidavit of service I have filed.
our order, how could you serve?
My lordship, let a copy may be served, my lordship.
I'll give another copy to him.
Yes, my lordship. I will accept it on behalf of the content.
Heard Mrs. Nag, learned advocate appearing for the applicant. Stop.
Mr. Arun S. Kumar.
Mr. Kumar, learned advocate, enters appearance on behalf of the alleged contemner and prays for an accommodation to avail necessary instruction. Stop. List the matter for further consideration. Yes, when can you come back? Yes, Mr. Kumar.
Yes, my lordship. My lordship, in the month of June, my lordship, because there is a vacation in there.
When is the vacation?
Actually, we have vacation in May, Your Lordship. We
That's-
don't have puja holidays. So we have only in May.
May from the first week it starts.
No,
Yes,
from
1st May to 31st May.
Entire May, my lordship. May month.
Then you file an affidavit incorporating whatever you have done.
Yes, that would be better, Your Lordship.
Yes, my lordship. I will file it.
Heard Ms. Nag, learned advocate appearing on behalf of the applicant. Stop. Mr. Kumar, learned advocate, enters appearance on behalf of the alleged contemner. Stop. The alleged contemner is directed to file the affidavit in opposition to the contempt application within when it is reopening your court.
1st June.
March, June.
within 5th June.
Yes, my lordship.
Your lordship.
Stop. Affidavit in reply thereto, if any, be filed by the applicant within a week thereafter. Stop. List the matter for further consideration in the daily supplementary list of this court on 20th, on 20th June, 20.
Or service of notice may be kept on the record as per your lordship direction. I have communicated.
There was no direction. What?
No, last time when I mentioned this matter, Marat has directed me to serve notice.
No.
Oblige.
Oblige, my lordship.
When I mentioned this matter, Marat has directed to communicate.
You keep it with you. You have
Yes.
recorded his appearance. ওনাকে দিয়ে দাও। Yes.
Oblige, your lordship.
Oblige, my lordship.
ওই যে ওই ডিক্রিটার জাজমেন্টে 1317 করে Yes,
Lord, I mean, item number 2 for the appellant.
item number 2 is
Item number 1.
connection ছিল শুরু থেকে এক জায়গায় আছে না আরো কোথাও আছে শোনো এখানে না এক জায়গায় আমি পাচ্ছি এটা চেক করবে যদি by reason of a typographical error the number of the suit by reason of a typographical error in the second paragraph of the judgment dated 21st March 2023 comma the number of the suit has been incorporated as quote unquote a TS number 1137 of 2014 in place and stead of quote unquote TS number 137 of 2014. Office is directed to effect necessary correction. Stop. This rectification shall be deemed to have been incorporated in the judgment dated 21st March 2023. The other portions of the judgment shall remain unaltered. ওটা ছাড়া আর কোথাও টাইটেলস দেখি yes এটা তুমি চেক করবে
Lord, I filed one application before your lordship for injunction restraining a defendants, as well as there are other applications, my lord.
first time it has come
My lord, no, second time.
you have
My lord, it has been sub, my lord, I've submitted
was
affidavit.
there any direction of us
My lord,
did we direct you to serve
no, my lord, I filed the application, filed the application for injunction, this injunction application or sir.
And the other, my lord,
That was served in 2017.
no, my lord, I've just recently in the
What are the other two applications?
the other two application, one is section 5 and another is substitution. My lord, that has been also served.
Can 3 was filed in October 2000.
2020. Well, this is can is a substitution application.
What was the suit for?
The shoot for was partition shoot.
Commissioner appointed,
No, my lord, partition shoot has been dismissed.
but the defend.
I'm the plaintiff. I'm the plaintiff.
Section 5, can 1. It is section. Can 1.
When did the matter last appear?
My lord, in the year 2017, 17 or 18.
The effect fresh service.
My lord, I have served. My lord, I have intimated. My lord, kindly see the my 23.
That is not the procedure, sir. There has to be a court's order.
My lord, one submission my lord can may appreciate. My lord, what is happening? My lord, during pendency of the appeal, they are raising construction in the shoot property. My lord, I have
You are sleeping since 2000.
no, my lord, no, my lord. I filed the injunction application 2020. Due to the COVID
Without
period.
an application for condonation of delay in respect of the appeal.
No, there is a grave urgency. My lord, substitution was
The urgency has
no,
occurred.
my lord, I'm submitting. My lord, in the year 2017, substitution.
Will serve afresh and come back to us.
My lord, I shall submit. My lord, kindly give an interim protection, my lord.
Yes.
Interim protection, one, my lord.
Interim protection in a defective appeal. You have not substituted also. You had no intent.
The
to
substitution period is pending since 2017. my lord.
You, it is upon incumbent upon you to take steps. Where you have stated that building is going on in your application.
My lord, kindly come to my application.
Your application is of 2017.
No, my lord, injunction application is of 2020.
20.
20.
We are in 2023. What is your averment in that application?
My lord, I have yes, my lord. I'm just coming to it.
Time period.
What is a can 3 of 20, my lord?
Panchayat application.
My lord, kindly come to page number 7 of my application.
Which application?
Can 3.
This is a further application for injunction.
No, one of single application. My lord, there are three applications. One is for section 5. Second one is a substitution, and third one is the injunction.
This injunction application you filed in 2020.
20, my lord.
What averment did you?
My lord,
make?
kindly come to page number. My lord, I have described from page number 5. My lord, relevant portion is my lord, paragraph number 6, page number 8. That the learned court will award in law in fact by not holding that the plaintiffs are entitled to the decree of partition being legal heir of the late Nur Muhammad, while the say deed of gift, my lord, there is a deed of gift which we denied in a year. But
Come to para. Can 3.
Can see the two parts.
my lord,
Para 8.
Where is the-
yes, my lord. but taking advantage of that position of the said first appeal, the respondent number 5 is trying to erect construction upon the suit property. Malad, there is already a construction. If it is not restrained now, Milord, they will complete, they will build Taj Mahal, Milord, there at Milord. Milord, the appellants at their best,
What did you submit?
Milord,
This is a court. It's not your drawing room.
Milord, beg to be excused. Beg to be excused.
How long you are practicing, sir?
15 years.
But you don't know how to submit before an appeal court? If they are building a Taj Mahal, you take steps. Is that a thing which is to be expressed to the court?
No, beg to be excused.
Be cautious with your submissions.
Milord, I beg to be excused.
Now, who has expired?
Milord, some of the respondents have expired.
What is the present status?
Milord, of the,
That was your awardment in 2020.
Milord,
What is
Milord,
your
may I show before your lordship, Milord? Milord, these are the position, Milord. that I put.
You obtained the property by virtue of a deed of gift.
No. They are claiming that my father, my father, they are my brothers and sisters. They are claiming that my father executed a gift deed in their favor. We denied this in the partition suit and we challenged it. But unfortunately, partition had been dismissed. Now, thereafter, Milord, they started the construction, Milord. Now, this is the position, Milord.
You cannot look into those. You ought to have filed supplementary affidavit.
Well, I shall, Milord. I shall. Kindly give me interim protection, Milord. Just this I pray, Milord. But within 1 week, I shall come back, Milord. Within 1 week, I shall come back. Milord,
That means by executing deed of gift,
this is their contention.
you are transferred to defendant number 226.
This is their contention.
No property has been given to you.
Yes, this is their contention. But we are saying that this is the fraud deed. We are saying this is a fraud deed. Milord, this is to be adjudicated in appeal. I shall satisfy your lordship. But so far my injunction application is concerned, Milord, I shall.
Entered appearance on behalf of.
Milord, in the first occasion, they entered appearance, but
Please the counsel.
Mr. Gaji. Gaji.
Did you mention upon notice to him?
Milord, I served the notice, Milord. I served the notice. Milord,
Have application then come.
Milord, I shall submit only one protection
Next date,
for 1 week, Milord.
advances will be taken care of. You serve.
Milord, may I show the present?
It's directed to serve the.
Milord, may I show the present position?
application upon the respondents, intimating that the matter shall appear on 8 May. And to file affidavit of service on the return of it.
Anybody entered appearance?
Mr. Saidullah Gaji something. In the first occasion, Milord.
And the appellant is also directed to intimate this order to Mr. Abdullah Gaji. who
Abdullah Gaji.
entered appearance, landed advocate, who entered appearance on behalf of the respondents.
Earlier.
On 27th April 2019, February 2019.
Milord, can you give me liberty to file a supplementary affidavit? Give me liberty to file supplementary affidavit.
Supplementary affidavit for which purpose?
Milord, for to show the present position of the property, Milord. And I have also
Third one come, we'll consider. Let us ascertain whether any construction is going on. You serve upon the respondents as well as upon the learned advocate. File an affidavit of service before us. Come on 8th. Yes. and
Great.
file an affidavit of service on. Yes, next. Agreed. Name of the commission.
My lord, sadly, this morning, very sadly, my lord, this morning, the appellant of opposite party number 1 has passed away. I'm representing the appellants opposite parties. There are 4 of them. While all the legal representatives are on record, nevertheless, she has passed away this morning, so I have to inform the court in writing and make the application for crossing out her name. So I think it would not be proper to carry on with this just now. Pushpa Devi Bangar, she passed away this morning.
To learned advocate, Mr. To learned advocate appearing for the appellant informs us that the sole appellant. How
No,
many
there are 4 of them. I represent all of them.
appellants?
1.
Has
Pushpa Devi
expired-
Bangar,
Has expired.
this
today-
morning,
Today.
this morning.
Please for an- and
I've only
please-
just got the information.
Please for an accommodation and please for an adjournment to take necessary steps in the matter. Stop.
Off the record, Miller, to answer your lordship's question, yes, it's all agreed. I thought it was going to be over
We have
today.
agreed, but after that, my lord, we'll agreed on the name.
When can you come with the application? You mentioned when you prepare it, you mentioned.
I will do
because
that.
We will put it.
I will do that.
Let the matter go out of the list for the present, stop liberty to mention.
Grateful to your lordship.
When you mention, you count, give the application number to my officer so that it can. Yes, next.
Grateful.
Lordship, in item number 4, I am for the appellant.
Yes,
I am for the appellant. Mr. Sudeep Sanyal is leading me. I'm kindly praying for not today, my lord.
sir, why do you mention? If you cannot come, why do you mention?
No, only for-
Yes, not today.
No, I am for the state respondents.
Dhar appearing for the petition applicant. Is coming, my lord, kindly, sir.
On the last token, I have submitted. On the last occasion, I have submitted that the vested property should be excluded from the partition suit as held by the trial court.
আজকেই পাঠিয়ে দিলাম। আজকে সকালে
ছিল তাদের খরচ ছিল হ্যাঁ আজকে ভুল করতে আমার
what you have done, you give different file. This is not the matter. Item number 5 is some suddenly. You are
Yes.
handing over file of one some joint.
ও আজকে সকালবেলা ওর হাতে ফাইলটা দিলাম সেটা হ্যাঁ ও, আর
পাওয়া যাবে না। Where is he? Call him, call him. Yes, Mr. What is that?
Written notes of argument. My client wanted to use this.
Written note of argument for considering injunction.
I could not persuade him.
No, no, what? Yes, give us.
একটা কপি দাও নাকি?
একটা কপি দেন। হ্যাঁ কি
বুঝতে পারছি না।
only 2 pages. Pagination করে দিয়েছো তো? I am at fault, my lord. I am at fault, my lord. Perhaps my lord's written notes of argument is not paginated. But
So, Mr. Dhar, in your argument, you have said that the
Yes.
court accepted the fact that you are hailing from Mitakshara.
yes, yes.
Where is that portion?
ওই জায়গাটা দেখাও না একটু। দেখাও না। আমার পুরো ফাইলটাই ঘেটে গেছে। Issue number 3 at page 54, my lord, of the stay petition. Inner page, the inner page. 8.
ইস্যু পেজ কত ভাই?
8. Inner page টা দেখুন দাদা।
8
Sorry.
But kindly recollect, my lord, at the cost of repetition, in initially there was a partition between father and amongst the 5 sons. Thereafter, sixth son, my lord, filed the partition suit.
He was
And-
not born then.
Yes. The
Separately, he filed the suit.
suit. Thereafter, his share was declared in that previous suit. Thereafter this, my lord, after the father has died, my lord,
in which the share of the parties there have been declared. And unless and until the order of vesting is stayed and the competent authority are restrained from giving effect to order of vesting, the parties to the partition suit shall not be entitled to enjoy the fruits of the case and enjoy the effect of vesting. The parties to the suit for partition shall not be able to enjoy the fruits of the declaration of share. And consequently, the order of vesting passed by the competent authority is required to be stayed, and the state authority is required to be restrained from giving any effect to the order of vesting or settling the land declared to be vested with any third parties.
I'm sorry to bark, my lord. My lord, vesting under West Bengal Land Reforms Act only.
Yes.
Bose.
Huh?
Mukti Chandra.
Bose, representing the respondent number,
State respondent 16 or 17.
state respondent being respondent number 17 and 18 here too, submits that here this partition suit is nothing but a policy one, and this partition has been filed to evade the ceiling, and some properties and or land declared to have been vested to the state have been included in the schedule of the partition suit, and in a circuitous way, the appellant want to restrain the state authority from giving effect to order of the vesting. And consequently, this interim order should not be passed. Stop. The suit property was originally belonged to one Satya Sadhan Sareng.
Satya Sundar.
Satya Sundar Sareng. And he left behind one son, namely Rakhal.
Chandra.
Chandra.
Rakhal Chandra.
No. Saroda Charan, originally belonged to Saroda Charan Sarengi. He left behind one son, namely Rakhal Chandra Sarengi. Rakhal Chandra Sarengi. Subsequently, Rakhal Chandra Sarengi and his 6 sons executed one deed of partition dated 17/10/1954, and the said partition deed was duly registered
Instead of
And
six,
after
instead of 6 sons, it would be 5 sons. Later, six son filed a suit.
later on, another son being Satyasundar Sarangi was born after the execution of the deed of partition. Sheikh Satyasundar Sarangi filed one suit before the Civil Judge Junior Division Second Court Kontai, seeking declaration of his share. And the said suit was decreed. In the meantime, it was found by the state authority that the Rakhal Chandra Sarangi held lands beyond ceiling limit, and accordingly a proceedings under the relevant provision of West Bengal Estate Acquisition Act 1953 was initiated, and Rakhal Chandra Sarangi was allowed to retain the land as per the ceiling limit prescribed in section 6 of Act of 1953. Thereafter again, it was found that the Rakhal Chandra Sarangi hold the land beyond the ceiling limit, and accordingly one proceedings under section 14(3) T within bracket 3 of West Bengal Land Reforms Act, 14 capital T within bracket 3 of West Bengal Land Reforms Act, which was registered as case number 33 of 1996, was initiated, and the land beyond the ceiling limit was vested to the state. Later on, it was found that the some land was converted to a trust property, and accordingly another proceedings was initiated under the provision of section 14(2) within bracket 6 of the West Bengal Land Reforms Act, and a certain portion of land was again vested to the state. Stop. In the meantime, the two sons of Premendra Sundar filed this instant partition suit, claiming therein that after demise of Rakhal Chandra Sarangi, the properties held by Rakhal Chandra Sarangi was devolved upon her 6 sons, and the entire family is governed by Mitaksara Law School, and accordingly they are entitled to hold the land as per the rule of succession of Mitaksara Law School. Okay. And in the claim, it was claimed that the said two sons of Premendra Sundar are entitled to get the share of the land left by Rakhal Chandra Sarangi, and they are also entitled to get share of the land held by Premendra Sundar as per Mitaksara Law land. After completion of trial, upon perusal of the pleadings and upon appreciation of the evidence, the learned court below decreed the suit in preliminary form.
Preliminary and part play. Okay.
Declaring that the property in respect of which the title of Satyasundar Sarangi had been declared by the degree passed in title suit number 443 of 1964 shall be excluded from case-schedule property, and the property which were excluded in co-schedule property but had not been mentioned in co-schedule property of the registered partition deed shall be excluded. In the co-schedule property of the registered partition deed shall be excluded, and the property which had been declared as vested to the state by the revenue officer, which would be reflected from a document admitted in evidence as Exhibit C, were also directed to be excluded. Stop. In the present appeal, the appellant has impugned the said decree in preliminary court, and this application has been taken out in connection with this appeal, virtually paying for an order to restrain the state authority from giving effect to the order of vesting.
The judge's view.
In the meantime, challenging the order of vesting, the appellee filed an appeal under Section 54 of the West Bengal Land Reform Act. And the said appeal was decided against them and against. In the meantime, Sir Satyasundar Sarangi assailed the order of vesting by preparing an appeal under Section 54 of the West Bengal Land Reforms Act before the DLLRO concerned. Said appeal was decided against the appellant therein, and thereafter the appellant has assailed the said order of the appellate authority before the West Bengal Land Reforms Tribunal by filing an original application which has been registered as way number 903 of 2011 and which is still pending for final adjudication before the tribunal. Stop. And it would not be out of context to mention that no interim order has been passed by the learned tribunal in the said application. So, it is well established principle that interim order is always passed in the aid of final delay, and no interim order should be passed unrelated to the final delay. And the court, which cannot pass the final order, cannot give such relief by passing interim order. By virtue of the sections 14X of West Bengal Land Reforms Act, civil court lacks jurisdiction to test the correctness of the order of vesting passed by the competent authority. In the case at hand, the land and the properties declaring vested has been included in the schedule of the partition suit, and direction has been sought for in this appeal upon the state authorities not to give effect to the order of vesting. And this court, sitting in an appeal over a preliminary degree passed in a suit for partition, lacks jurisdiction to pass any order setting aside the order of vesting. Consequently, this court lacks jurisdiction to pass interim order staying in operation of the order of vesting also.
And this was sitting in the happy over
No,
in the suit for what is lack jurisdiction.
lack jurisdiction to cannot cannot pass. Cannot pass aspect. Yes, staying in operation of the order of vesting. Accordingly, in course of submission, Mr. First place is reliance upon a judgment delivered in case of Mulchand Jadhav and another versus Raja Buland Sagar Company Limited, Rampur and others, reported in 1982, Form 3 SCC, page 484. এটা দেখে নেবেন, হ্যাঁ?
তিনটে
এই যে and an unreported judgment passed by the Honorable Division Bench, coordinate bench of this court in the case of Anil Patra versus Srimatta Angurbala Pramanik and others, passed in SAT number 298 of 2017 on 22nd August 2017. So both the said judgment, in our opinion, are distinguishable on that, and has no manner of application. So this application is thus dismissed. However, without any order as to the. Let the hearing of the appeal be expedited.
Yes, ma'am.
Huh?
Yes.
Any place take it further.
Acha.
You are
For the respondent number
advocate on record. Who is the record?
Advocate on record ke?
Who is your advocate on record? For respondent numbers?
Respondent.
3 to 6, 12.
Yeah, just. Actual rules of evidentiary hearing of the appeal be expedited as Mr. Mondal, the advocate, has entered appearance on behalf of the respondent numbers.
3 to 6, 8 to 12.
And as Mr. Ghosh, the advocate, has entered appearance on behalf of the respondent numbers.
State respondents, state respondents.
What they?
Respondent number
17 and 18.
17 and 18, service of notice of appeal about the said respondents is dispensed with. The appellant shall put in the requisites to effects for service of notice of appeal upon the remaining responses. Within 2 weeks from date, within 2 weeks for service of notice of appeal upon the remaining responses. For the informal paper book, 4 weeks after the arrival of lower court records, liberty to mention. Application to dismiss.
Deeply obliged.
Yes,
Appeal is pending.
tribunal.
LRTT, LRTT.
Any decision, any state taken by the state authority will abide by the result of that.
No, state has already been taken a position.
We don't have
Yes, don't,
jurisdiction to
yeah, naturally, that order cannot be passed.
State. The appeal itself will be
We have arrived at a finding, we cannot go in.
Yes. You know, he should go back to the Contai court and make necessary application. Yes,
what we will.
So how you are acting? You saw your appeal. So there-
no, he is in aid of the appellant. He is in aid of the appellant.
Suffered the injury, you got.
No, he is in aid of the appellant.
he wants to make his presence.
Deep-
Yes, next one.
Deeply obliged, deeply obliged. পেজেসটা দিয়েছেন দেখা অসুবিধা হয়ে যাবে
Hello, I am for the respondent. Unfortunately, I have lost the brief. Please allow me 7 days time to.
First time it has come. It has come for the first time.
No, no, no.
Sure for the, what is the application about? Is it suit for?
And I think out of letters of administration, it's another from a probate case.
What interim order you want?
You guys know interim order.
was the- You are the appellant, Vibhuti. You are Vibhuti. Vidhu Bhushan. What interim order you are wanting? You are the appellant.
And not the third party notice.
Where is your application?
And one.
My lord, this is good for probate. The
Is occupying the property.
both brothers are occupying the property. Earlier, there is a partition suit that in the partition suit there is a stay for till dispose of the.
Who was the petitioner in the court below?
I am the petitioner.
What is your all of them? Hindu Bhushan and everybody
Yes.
appearing for all.
Oh, yes, I am applying for all.
Now it is, what is the property? It's a residential house.
Residential.
You people are residing there.
Residing there, and there is an injunction in the partition suit.
We are not concerned.
Huh.
Petition suit, what injunction is there?
Status quo?
So that will be maintained.
No,
That
there is
you
no.
will not
Well,
alienate
just my lord, give me only 7 days time. I will file a opposition. Just give me 7 days time. My just I lost the brief. My lord. Unfortunately, I have lost the brief. I have to reconstruct the brief by taking copies.
Applicant was a plaintiff in the suit, in the probate suit. Subsequently, when the pendency of the suit, after the court has been used to take the written file,
I know that
they are changing the nature and character of the suitor by collecting many materials and.
no, sorry, no.
Any suit for partition is pending in between you.
Yes,
Suit for partition is pending.
suit for
The
partition
said suit, order of status quo
is there.
still in force.
Still there. My lord,
Status quo is already there.
there.
What, collecting windmill materials to do what?
No,
Fresh construction.
Yes, your lordship.
Where they will make fresh construction.
they may raise this issue in the lower court. They may raise this issue in the lower court. I'm changing the nature and character. There is an injunction.
You given a copy to him.
Furthermore, my lord, this appeal is not maintainable here in this court.
Sir, either you oppose the injunction or don't make hearing on the merit of the appeal. We are considering the injunction. You want to use an opposition. His allegation is that you are making construction.
No, we are not making.
We will record that.
Yes. And I will show them any photographs. We are carrying out any construction. We are asking him, show any photographs that we are constructing.
So there was already direction for affidavits.
Yes.
Have you filed?
No, my lord, I lost the brief in the meantime. That's what I'm paying for extension of time for filing affidavit in opposition. Just give me 7 days time, my lord.
The appellant files a supplementary affidavit in connection with the application being 1 of 2020. So let the same be kept on record. A copy of the same has been handed over to the learned advocate appearing for the respondents. The learned advocate for the respondent prays for extension of time to
File affidavit of opposition.
file the affidavit in opposition. Such prayer is considered and allowed. Let such affidavit in opposition be filed by the respondents dealing with the averments made in the application and the supplementary
Yes,
within a week from date.
yes, my lord.
Stop. Reply thereto if any be filed within a week thereafter. Stop. List the matter for further consideration in the daily supplementary list of this court on 16th of May.
We are undertaking, giving undertaking that we are not doing anything, my lord.
Then we dispose of the application.
No, sir, give me opportunity to file.
Come tomorrow with instruction, we will.
I have no brief, I will take copies from him. I have no brief. I have misplaced the brief.
You are giving an undertaking that no construction you will make. What will be the utility of keeping the application pending? Their injunction is that do not change the nature and character, do not alienate. This is his prayer. What remains then?
Just give me an opportunity. Just give me an opportunity to file opposition.
We are disposing of the application.
Must give me an opportunity to file a petition opposition. Otherwise, I lost credential to my client.
Eh?
Otherwise, I lost credential to my client.
Where have you stated that? Of the supplementary. There is a subsisting status quo in the partition suit. What is the problem pertaining to the same property? Come on that date and take the injunction.
Yes, ma'am.
We release the matter within 10 days. Yes.
I'll retype.
Yes.
Malad, I am for
What is the
the
application?
Malad, the application is for Malad stay of operation of the impugned judgment.
The adjustment. This is the first time it has happened. You serve Mr. Gandhi.
Malad, only one thing I will be praying,
Okay.
Malad, since I'm in possession of the property. Malad, the suit was Malad of the proceeding was a probate Malad proceedings. Malad, the proceedings was a probate proceedings. Malad, now the that Malad proceedings was dismissed.
Instance.
My instance. Malad, I was the executor of the will. Malad, after the demise of this test refused. Malad, now it was. Malad, that is for in the appeal. Malad, the application is to that effect. Malad, since I am in possession of that property, Malad, it the respondents are the one of the brother, Malad. Malad, he is trying to Malad create disturbance in the property As such, my lord, I am praying for my lord stay of operation. Yes, my lord. He's to my lord, since I am my lord in possession of that property, my lord.
The appellant is directed to serve copy of the application upon how many respondents?
My lord, there are respondents 7,
Upon the respondents
9, my lord.
intimating that the matter will be taken up for further consideration on 16th May and to file an affidavit of service on the returnable date. So this the matter, accordingly.
My lord, only one thing I will be praying, my lord. I am praying for my lord only limited period, my lord, stay of operation of the
Come
order.
back to us. You are in possession. If you
Mal-
is disturbed, you come back to us. We have made it returnable.
What's clear operation? Clear
Clear, not stay of operation.
My lord, now, my lord, what they are,
alienating or.
yes, my lord.
You are.
They will be creating third party interest in the property.
Has been dismissed.
Yes. Now, my lord, I am in possession, my lord. Now they will be crying, my lord, coming, my lord, and disturbing my voice. To secure the position, my lord, I will be praying first.
Lord, 9, my lord, Mr. Anirban Das is appearing, my lord. He's not well, he's not in court today, but I'm praying for not.
Takes it up after vacation because my client will
My lord,
not be in station. My lord, I have mentioned, my lord,
my lord, only
at the
not
time of
today.
mentioning also I have pointed out to that effect.
You file your
And-
opposition to the order for that is.
That is section 146 application is their application for, but they have not deposited the court fees for 1 year. Thereafter, my lord, your lordship directed the matter to go out of list. Thereafter, the
Oh,
blood
this is
deficit
not
court
that
fees.
matter. Oh.
No, my lord.
Thereafter, the deficit court fees. No.
Finally,
My lord, I'm praying for just not today, my lord. Kindly fix it today, tomorrow, or
we'll
day
fix
after
it as
tomorrow.
ascertained. What are the application?
Yes, my lord, the application is, my lord, they have, my lord, filed the appeal without, my lord, proper court fee. This is suit for recovery of money. Order 7, Rule 11 application is, the plaintiff is being rejected. Initially, revisional application filed. Revisional court said it's not maintainable. Thereafter, the take back filing of this appeal without court fee. Your lordship directed. Thereafter, they have not made the good. Your lordship directed the matter to go out of list. Now, the deficit court fee is being paid and application is being filed, for condonation or an acceptance of the court fee. Your lordship knows, since the time is at the time of filing of the appeal, if the deficit court fee is being deposited after that, the application has to be filed as per section 146 for enlargement of time by your lordship. That is being prayed for in one of the application. Another application is for
146 or 148.
148.
148.
148. Yes, enlargement of time. 148. I stand correct. So your lordship kindly takes it up after vacation. There is no urgency in this. My difficulty is opposition. They will.
No, it has been, the plaintiff has been rejected, rule
Regular
11B. Rule 11B most probably,
Regular appeal now.
by the learned court below.
Court below. So they preferred civil revisional application.
Sir.
We took out the point that now it's a regular appeal.
Right.
Thereafter, civil revisional application was dismissed, giving them liberty to take appropriate steps. Now, thereafter, the appeal with section 5, non-deposit of court fee. So that your
But I'm praying for just.
Filing the appeal also.
Yes.
That since they approached the revisional court from the.
And there are
So you want to give an opposition to that?
my problem will be my
One
client is in
application.
Canada. My client will not be in station. He will be leaving the station. That's why at the time of mentioning, I made before your lordship that my client will leaving the India for marriage ceremony to be attended. He will not be present. That's why I praying to.
Very good. You.
Well, only not
But
today.
there are 3 applications.
Lord, I find 2
Mr.
applications.
Anirban Das is appearing, my lord.
No, there are 3 applications, 1, 2, 3.
Yes, one is for section 5. Another is for recording the death of respondent number 1. And can 3 is for appropriate order for acceptance of deficit court fee.
Kindly fix it tomorrow, my lord. Mr. Das will address your lordship, my lord. Oblige, my lord.
Yesterday also it was there. No one appears on behalf of the appellant and no application has been sought for. Stop. Let the matter go out of the list for the present. Stop. Liberty to mention.
Yesterday, Mr. Dotto appeared in this matter. My lord was pleased to my lord. This matter was heard yesterday for release, and my lord was directed to release this matter as there is some deficit court fees to be paid. If that matter.
Why you have kept taking the list?
And there was a liberty to mention. Yes. Yes.
It was on 5th April, we said.
No, yesterday this matter was taken up, my lord. That Mr. Dotto appeared in, Somen Dotto appeared in this matter, my lord. 20 rupees deficit.
What did we say?
My lord was pleased to
Pass an order tomorrow,
yes.
yesterday.
Yes. Other side was also mentioned, present.
Where was ছিল? Yesterday, order was recorded. Order recorded. Will be out of list you mentioned.
With the liberty to mention, as the last order was.
We don't know whether the first step Hon'ble direction or not.
No, it was recorded. It was
If
recorded.
they will ascertain it as to whether any order has been ordered passed. Then somebody must have taken. ফাইলটাকে আলাদা করে রেখে
Other side was also present.
Already we have heard it.
Did
Yes,
you-
next.
Appearing for the my lord, appellant
April lordships heard this matter and directed to 5 separate appeal. Remember, Parthopratim I argued the matter. I filed a suit for partition. The partition has been dismissed. Counter claim has been allowed. I appeal mentioned both the matter. One matter is come before your lordships, but new appeal is not come before your lordships.
Not coming. Why?
Yes, 176.
Why?
I don't know. I give number both the number. It was out of list. I numbered with the both the numbers. But old one is come, but new was not appearing for lordship. I am serving the copy of my learned friend.
Wait. What was your what happened to the what is the application in respect of the first appeal?
My lord, ST application can one
Suit
for partition.
Counter claim.
Partition was dismissed and counter claim has been allowed. Initially,
both the appeals has to be.
yes, sir. I written down the number. The number of the
If the these two
I am having copy of my land. My lord.
Yes,
come next week.
My lord.
If you send for requisition, let it come.
Not this week.
grateful, madam.
Get.
I am for the opposite party respondent.
My lord, in this matter, my lord, Mr. Rahul Kormokar, my lord, learned advocate, my lord, is appearing for the appellants. My lord, he is on his legs before another court. My lord, I'm praying for a short passover.
You are for the respondent.
I am for the respondent.
What is the application?
The application was stay application.
What is the suit for?
The suit for this is the my client is the landlord tenancy, my lord, for eviction of the suit tenanted portion. That is.
You are the landlord.
I am the landlord.
The suit for eviction.
Suit for eviction.
You are the appellant here.
My lord, I am the appellant, my lord. I'm the tenant.
Decree. Any
Decreed order passed under order 12 rule 6.
admission.
Order 12 rule 6. They are not contesting the, my lord. Later on, their term order has been passed. Decree has been passed. My lord, I give you a short list of dates so that my lord the.
If my lord kindly passes over the matter for the time being, my lord. I'm so grateful.
My lord, the then lordships day after tomorrow will taken.
So my lord, if my lord kindly makes it not this week, my lord, I'm so grateful, my lord. So good. Shombar, sir. I'm for the plaintiff. I'm praying for short passover.
What are the applications? Oh, no.
No, my lord.
It's for the appellate.
Sushant Pal, my senior. I'm for the ECL. I'm for the appellant.
You're for the ECL. Now, what are the applications about?
There is a case in about award, my lord. My lord, please give me a short passover.
Passover. Yes.
21.
21, my lord, I'm led by
20 wrong when it is given. Yes, 21.
21, I'm led by senior Mr. Gupta, my lord. He couldn't come to court due to some personal reason. There's an, if your lordship kindly just makes it not today, my lord. He was all along there, and there's an, my lord, only not today, my lord. We would be doing the matter tomorrow. There's a cataract operation of my mother, so my lord, he has gone this. So that is.
But the yes, thanks.
Great. My lord, 23, I pray for not today. Because the advocate on record, Mr. Dilip Kumar Sadhu, is engaged in another court.
এটা দিলে না মানুষ কিন্তু ইয়ে ভাববে এটা চলবে ডেয়ারিং মামলা চলবে কি করে
Fifty-six. You are in 26.
No, now in 20, Lord, it was 22-0.
It was said that you were not, you were indisposed on the earlier day.
No. Earlier day, I was some other court, I could not come.
When we have kept it? When did we keep it?
Today it is in the
No, not you. On the this.
number
It was it kept? 23.
20 number
20.
20. Oh, not this week হবে নাকি সোমবার
It on Monday. We'll be there on Monday.
Yeah.
Monday, write it down. Monday.
না আজকে না মানডে মানডে
All the list.
27,
28, 29. In this matter, I'm appearing on behalf of the appellant.
Appellate. Yes.
My lord, I came before your lordship challenging the order of Honorable Mr. Justice Mantha. And
Just one moment. Let us get the file.
And my lord, your lordship was pleased to treat my writ petition as my application and directed the learned advocate of the customs to file the affidavit in opposition and to make, yes, my lord, affidavits are complete, my lord. But Mr. Banerjee is not here.
Start, you show us the facts.
Yes, my lord. In the year 1998, my lord, my truck was carrying salt from one place to another place, which was seized by the customs authority. Thereafter, my lord, customs authority illegally imposed a fine of 10,000 upon me and also direct me to pay the 40,000 to release the truck. But I denied. Matter was referred to the revenue tribunal, and revenue tribunal waived all the penalties and released the matter. But truck was not handed over to me, my lord. Thereafter, I came before the Honorable High Court with a writ petition, and Honorable Mr. Justice Oshim Banerjee Malot passed the order after hearing, passed the order to release the matter in the year 2001. Thereafter, my lord, in this, your lordship kindly come to page 17, my lord.
Page 17.
17. May I place it, my lord?
Order dated?
Order dated October 3, 2001.
In your, that you have annexed where?
In the writ petition, my lord.
Petition filed to the.
Yet again. In the writ petition, page
Then what is
17.
this order? Rajshekhar Mantha, his lordship passed on the 18th of June.
Rajshekhar Mantha's order in the memo of appeal, my lord, which was rejected without any hearing, without hearing me.
Oh dear. After the, which order is under appeal in the present?
Rajshekhar Mantha's
That is 18th of June 2018.
right, my lord.
First place that order.
Your lordship kindly come.
Yes.
The impugned order, last page, my lord. The writ petitioner is aggrieved by the fact that a truck being registration number WMK 8096 seized by the customs authorities on 28/6/1998 and as directed to be returned by the Honorable Court dated 3rd October 2001, passed in WP 15453W of 2000, has not been so returned even as on date. The writ petitioner has unfortunately not approached the court since 2001. 18 years have been passed and not much is likely to remain of the truck or a machine. Hence, no order can be passed. My lord, this is not true. In the year 2005, my lord, my learned advocate sent a notice to the customs authority to return the vehicle, but they couldn't because some of the parts of the truck was stolen from their custody. And Supreme Court is very clear on this point, my lord. The authority seized the vehicle or
Which was the order which was first in the first writ petition?
Your lordship, kindly come to the page 17 of the writ petition.
Yes.
October 3, 2001.
Do you have an extra copy of the order?
No, my lord.
Yes. Now, 2005, you have reported. What is the wrong with this order, Mr. Pal?
No, my lord. Repeatedly, I visited the customs authority. They refused to return the truck. And they said
that you ought to have approached in 2005 itself.
Yes, I also, at that time, my lord, different set of lawyer was there.
That cannot be an excuse, Mr. Pal.
No, lord.
Appreciate the situation.
In
First order was in October 2001.
Right, my lord.
The next writ petition was filed for implementation of that order.
Right, my
Must
lord.
have been.
No, my lord. By this time, they have preferred an appeal challenging the order of the Honorable Mr. Justice Oshim Banerjee. That appeal was after hearing dismissed. Thereafter
was it dismissed?
Dismissed in the year 2000. How far I
Please
got
come up
from?
with a list of dates. No? You have to come up with a list of dates.
Then your lordship, can you take this matter on Monday?
How many times we will adjourn, Mr. Pal?
This is the first time, my
you have
lord.
to satisfy us
Yes, my
Not
lord.
the first time because affidavits have been exchanged.
Yes, last time Mr. Banerjee took the time for complete the
Please
affidavit.
answer this query. We understand that your truck was directed to be released
Right,
by an order passed in a writ petition in October 2001.
right, my lord.
Thereafter, the second writ petition which was filed, which was disposed of by Justice
No, my
Pantha,
second appeal was filed by the customs authority,
maybe
which was
they
after.
did not obtain any stay.
No, my
What
lord.
prevented you from filing contempt application at that time?
I was not there, my lord.
So that
Different law,
For
set
that
of
reason,
lawyers.
we understand, Mr. Pal.
I understand, my
For
lord.
that reason, how we can revive the situation after 18 years?
My lord.
Is it possible for us to revive the situation?
But the Supreme Court is very clear on this point, my lord.
On these facts, Supreme Court has said 18 years.
Yes, my lord.
Well,
The
please-
reference was given, your lordship will get the
Reference, you
reference.
kindly place the facts of the case. You are placing the order of October 2010 to 2001. Place it.
The writ petitioner's truck confiscated by the custom authority initially a
Penalty for rupees
penalty for rupees 10,000 was imposed upon the writ petitioner, and the writ petitioner was asked to take back his truck upon deposit a sum of rupees 40,000. The writ petitioner did not agree with the said order, and ultimately the matter was set at rest by the appellant tribunal by their order dated 23rd February 2000, wherein the writ petitioner was exempted from the charge made in against him, and appellate tribunal directed to return the truck. The order of the appellate tribunal was being annexed in the writ petition,
Page 49.
appearing of the page 49 of thereof. My lord, page 40.
Where is your writ petition?
Yes, my lord, I am pleased.
4095. All right, you continue placing the order. Mr. Pal, finish off the order.
Yes, my lord. 49 of thereof. The grievance of the writ petitioner is that.
One second.
The second paragraph, my lord. The grievance of the writ petitioner is that the customs authority are now not in the position to return the said truck in running condition. Mr. R.N. Das, learned counsel, appearing on behalf of the petitioner, has relied on two Supreme Court decisions reported in AIR 1967 SC 1885 and volume 35, excise law times page 244. The relevant portion of the apex court
Has been quoted
apex
below.
court judgment is quoted below.
Yes. Now kindly come to internal page 4.
Sorry.
After the quoted portion come.
Yes, my lord. On the fact
No,
that
you need not place those. This is quotation from the judgment.
right, my lord.
Kindly come to internal page 4 of the order. After the quotation.
Yes, my lord.
Place from there.
Yes, my lord.
Relying on the said two decisions.
Relying on this said decision, Mr. R.N. Das, learned advocate for the petitioner, submit that it is the duty of the customs authority to return the said truck in running condition as it was confiscated. In such condition by the customs authority through border security personnel. Mrs. Mrs. Mita Banerjee, learned advocate appearing on behalf of the respondent authority, submit that the customs authority was not responsible for confiscation, as the confiscation was done through the border security personnel, and the damage, if any, caused the truck should be made by the border security force, but not by the customs authority. MS Banerjee further submit that she should be given further opportunity to take further instruction in the matter. In my view, no fruitful purpose will be served in adjourning the matter. With regard to other submission of Mrs. Banerjee, I find no justification, as the apex court in the aforesaid decision quoted supra categorically held that customs authority are deemed to control of the truck in question, and as such, they cannot avoid their responsibility. In view of the matter, I direct the customs authority to hand over the vehicle in question to the writ petitioner within a period of 1 week from the date of communication of this order, as the time of taking delivery of the said vehicle in question. The writ petitioner would be entitled to have the said vehicle surveyed by approved surveyor from the customs panel, and the customs authority in turn would pay amount of loss and or damage, if any, as essential by the surveyor. Assessed by the, I'm sorry, my lord, assessed by the surveyor. The said amount would be paid by the customs authority within a period of 3 weeks thereafter. My lord, the customs authority failed to survey the vehicle with their panel surveyor. The vehicle was surveyed, according to them, my lord, by a person who is not a panel surveyor, and he have no qualification to survey the vehicle. And he assessed the 1,48,000 damage.
Where is your, after this, the vehicle was surveyed?
Yes, my lord. Your lordship kindly come there, opposition, my lord. Your lordship will find.
Yeah, before opposition, what is your, what fact you have stated in the writ petition after this judgment? You have received 1,48,000.
48,000, my lord, which is, but I challenged the report of the surveyor.
After receiving the money?
After receiving the money, because this is not a proper survey, because he is not, according to judgment, my lord, he is not a panel surveyor, and he have no qualification.
Come to the writ petition, paragraph 3. From paragraph 3, you place.
My lord,
Place.
that the petitioner states that in pursuant to the said judgment and order dated 3/10/2001, received rupees 148,000 as loss.
When?
And
when did you receive that amount?
I received this in 2009.
2009.
My lord, your lordship kindly come.
Where have you?
Yeah, your lordship kindly come. Page 23 of their opposition, my lord.
No, no, you have not stated in your writ petition.
No, my lord, at that time, we are ignorant about when he received the,
Acha, let us see what you have stated in the writ petition.
yes, my lord.
Then he met with the superintendent several times, did not hand over.
And my lord, the customs panels, the 148,000 as loss and or damage as assessed by the customs panel surveyor. But the superintendent Jolongi Customs Preventive Unit PO and PS Jolongi District Murshidabad did not return the said vehicle to the petitioner till date. That the petitioner states that he must with the Superintendent Jolongi Customs Preventive Unit PO and PS Jolongi District Murshidabad in several times, but the said authority did not hand over the said truck to the petitioner till today. That thereafter your petitioner sent a notice dated 24/11/2017.
That is after 16 years.
After 16 years. Yeah,
Mr. Pal, will you explain to us this amount of 1,48,000 which was paid to you?
Yes.
This must have been paid after a purported surveyor conducted an
Yes, my lord, that was challenged, my lord. And they have admitted in their opposition.
What they have admitted?
Yes.
পিটিশনে ওটা বলেই না, এই পিটিশনে বলেছিল যে টাকাটা দিয়েছে, যেটা মান্থা ডিসমিস করলো। এবার ও রিট চাইলো টু হ্যান্ড ওভার দি ভেহিকেল, ভেহিকেলটার কোনো এক্সিস্টেন্স নেই।
আমি কিছু টাকা
What is their stand in the opposition?
Yeah, my lord, in page 7 paragraph.
Where is the opposition? Have you filed?
We have some.
Where is the opposition?
Opposition আগের দিন দিয়ে গেছিলাম।
এইটা তো রিট ফাইলটা এনেছো, এটা নাম্বার পরে। Where is the appeal? Opposition has been filed. You have used a reply also.
My lord, they have also filed a reply. My lord, we have prepared a short list of dates for your lordship, kind consideration, lordship. If your lordship kindly, it will be cleared everything, my lord.
Yes.
From the very beginning till date, what happened, my lord, we have described in our letter.
First, let us get the opposition. Where is the opposition?
Sir, we have last occasion, my lord, we have filed.
No opposition. একটা কপি করেছে। One copy you filed.
Two.
On your lordship's copy and your
ওকে দাও, দেখে দেখি। এখান থেকে দেখো অপোজিশন।
রিটার্ন করেছে, কন্টেন্ট ফাইল করেছিল বলে।
বুঝতে পারছি। They preferred an appeal on 6th of June 2005. Now, any order was passed in the appeal?
My lord, appeal was dismissed.
Appeal was dismissed when?
6/6/2005, my lord, in my internal
2006.
3, my
Appeal
lord.
was dismissed. Very good. Then 19th of October, what happened?
Do we have the superintendent of custom technical branch directed the Jolongi the concerned division to appoint a panel surveyor, because my lord, we don't have an independent panel surveyor, so we have requested the regional.
No, tell us October 2001 the writ was or disposed of
Which were disposed of.
with a direction upon you to return within 7 days
7 days.
and to appoint a surveyor to ascertain the loss. So instead of 7 days, you waited for 4 years. Since the appeal was paid, was there any interim order in the appeal?
No, my
No, it is not.
Any contempt application was filed?
No, they have not filed any. It is not actually.
So you are governmental authority. Why didn't you comply with the order? From 2001 October till the date of dismissal.
Cannot improve our case because the files, many papers are missing. Whatever we brought the old file and whatever dates we could get from the file, my lord, we have to assist your lordship, my lord.
No, then you have nothing to explain the delay, Mr. Banerjee. Now what happened? You prepared a check of 1,48,000. He did not receive that. He has
Subsequently, he has received 2009.
When did he receive?
My lord, it was deposited. I can give you the date of deposit, the 7/12/2009.
Page 23 of the
23 of the opposition, my lord.
Page 23. Now, why here there is a CPAN number? Page 23 at the bottom, it refers to a CPAN of WP 15453. That is not the writ petition where the Justice Banerjee disposed of.
154. Yes, my lord, this is that writ petition number.
That
This is a writ petition number of 2000.
Now, what was the order pass? 2009, order dated 23rd October 2009.
Yes, my lord.
Yes, a computer.
It will not appear, my lord.
But 2009, my lord, it will not.
2009.
Probably, my lord, this is content.
আচ্ছা, the requisition, the writ petition, সুরজিৎ, এইটার কানেকশনে তো একটা কন্টেম্প্ট ফাইল হয়েছিল দেখি। এই রিপিটিশনটা কি ওয়ান
This is not this writ petition, this is the earlier one.
হ্যাঁ, জাস্ট
Yes,
অসীম
yes,
ব্যানার্জি ওইটা অর্ডারটা রিপিটিশনের ফাইলটা yes, it is that writ petition.
Yes, my lord.
এটার কানেকশন কন্টেম্প্ট ফাইল হয়েছিল সিপিএ না তো এই কি আর ট্রেস করতে পারবে, তখন তো কোটে কোটে ফাইল করে দিল। So when you ultimately received Mr. Pal in 2009,
Yes, my lord.
which was tendered to you in 2006.
That time, my lord, they surveyed the vehicle not according to the order of the Honorable High Court.
What is your prayer?
Prayer
Understanding of the way.
or, my lord, according to Supreme Court judgment, the compensation. Per value of the, I'm entitled for value of the goods.
This is the, my lord,
Your lordship kindly come to the judgment which referred by Mr. Das.
Mr. Pal, judgment will let us understand the facts.
Right, my lord, I'm sorry.
In October 2001, court directed that you return the vehicle within 1 week. They did not return the vehicle.
Vehicle, no, my lord. Whenever we go, they have they pressed us. They write it. You are getting good running condition. I have stated. Not only that, I made a diary also with the police. Police refused to take the diary. I sent the letter by post. Your lordship kindly come.
Mr. Banerjee, when you cannot improve, what do you suggest?
my lord, this is the skeleton of the vehicle. He may take it as his various basis. And our representations are there repeatedly that you kindly take over the vehicle or take the check. Page 27 of the opposition.
Page 27.
Yes, my lord. This is the handwritten letter. of the department.
We have requested, my lord, you take it, otherwise you will not be responsible.
You not be responsible.
Then what is, this is a letter of 2006.
21st April 2006, my lord. May I read, my lord?
That is after the appeal was dismissed.
Yes, my lord.
You became generous enough to write a letter that now kindly come and take away your ramshackled vehicle.
To save their skin.
Now, before that, my lord, also on 5th April 2004, we have requested page
Where is
20,
that? Where
page
is that?
26, my lord.
Huh?
Page 26.
Page
And
26.
below in their
We will come back to you. We will come back. That is also 2006. That was on 5th April. 27 was on 21st April.
4th April, there, we are.
So admittedly for the period from October 2001
Yes.
till, if we take 5th April also, your appeal was dismissed in June 2005.
June 2005, my lord.
So there was no order of stay and no order. So from 2001 till 2005, you kept quiet. You neither did tell him that come and take the vehicle, nor you said that all right, we are assessing this amount as compensation or for the damages. Then who is to pay for that period?
The things which transpires, normally when an order is challenged before the division bench, until and unless the finality of the proceedings culminate, on the one hand, if I comply with the order, my division bench appeal will be infructuous.
Naturally, because that
Yes,
is
ma'am.
why, Mr. Banerjee, you have to obtain an order of stay.
Definitely, normally if
To
the
ask
party-
your officer, settle the matter. What he will do with the truck? Nothing will happen. He has got 1,48,000. This is a Tata 407 Mosby.
17 years.
17 years.
My lord,
Come with instruction.
And my lord,
Wait, Mr. Pal. We are trying to assist you. Apply your good office, Mr. Man.
Office will go. Well, my office will go away in doing this. Well, if some practical approach could have been done, we could have done it. Otherwise, over here, money is gone and all the skeleton of the truck is there. He may take the delivery of the skeleton in truck. Now, if your lordship goes into the merits, the delay of so many latches and lordship knows 3 years maximum your lordship can extend.
Oh, you want to gain premium on your own conduct.
Conduct may be bad. The contempt proceedings, lordship knows the settled position of law. 1 year if you sleep, thereafter you cannot proceed. Now over here, the continuous cause of action, we have shown our bona fideness with regard whatever papers are there. We have given back the check. Whatever is our assessment, if he is dissatisfied with the assessment with regard to the quantum, he should have filed a suit against the customer. With regard to the admitted claim, whatever is possible, we have done. He, on the other hand, has been
Mr. Banerjee, I obtain an order from a writ court. I serve it upon the officers. What is the duty of an officer? He has to either go and test the order in appeal. In appeal, you pray for an interim order. Admittedly, there was no interim order. Then what? How do you explain the period? This is in blatant violation of court's order itself.
That we appreciate, now everything has gone, 2001 to 2023. None of the officers or even the papers were not available after March. From the superiors, we could, however, gather it from the dust. Now, in 2006, the incident happened. In 2017, he took 11 years. That is fatal, for his client. And it is a monetary claim, my lord.
And my lord,
Normal civil suit 3 years.
File has come.
This read file, the original read file of Honorable Justice Oshim Banerjee.
Yes.
That has come.
That is the read file.
In connection with the content matter. Well, which my learned friend has challenged the appeal, that file might have come.
Oh, you are saying that?
Yes.
After the appeal was dismissed, they have taken no proceedings, my lord, and
Explain your conduct, Mr. Pal.
Yes.
my lord, your lordship kindly.
We are trying. You have no explanation. From 2001 to 2005, appeal was pending. You could have preferred the contempt application. You preferred the contempt application. It appears in 2009,
My lord,
and that must have been dismissed.
my lord,
That must have been dismissed.
kindly appreciate my position. That time I was not there. Different set of lawyer was
That cannot be
there.
a ground, Mr. Pal. Can that be a ground? Your lawyer was negligent.
But
so you take steps. Your lawyer was negligent. He did not take steps. You are citing it as an instance in this proceeding after 18 years. একটু লিখে নাও তো এটা কোনটা রিট পিটিশন নাম্বার আমি বলছি। Where is your reply?
Reply, my lord.
Earlier cost title.
15453.
Cost title you have given.
W of 2000.
Written number, my lord.
2000. Okay, I have to content ওইখানে ছিল
Contempt হচ্ছে CPAN number 479 of 2009 in connection with 15453 W of ওইটা এই মেন ফাইলটা এলেই ক্যানটা চলে আসবে।
CPA has to be otherwise equalization. Otherwise, that file will also not come. Kindly.
Yes. Now it is not usual. That was the previous practice.
Yes.
Contempt in another court.
Yes. But now that since that thing, the files are in a what to say, in a
Hard
disposable condition. Therefore, my lord, your lordship's order is required. Otherwise, that file will not come.
সুরজিৎ
Along with the order dated so and so.
অর্ডার করার দরকার।
My lord, kindly pass a order.
না বলছেন তো,
Oh,
না,
okay.
না।
Or requisition.
Actually, hard Mr. Pal learned advocate appearing for the appellant and Mr. Banerjee learned advocate appearing for the customs authority.
And
This the matter as for orders. We will pass our order on that. Bring the file.
as your lordship, please. But one thing, your lordship, kindly consider, my lord, that after the dismiss of the appeal, they have not taken any further steps. And the order of the Honorable Mr. Justice Oshim Banerjee reached its finality.
Which Supreme Court judgment you are relying upon?
There is, my lord,
That,
in that
Justice
order,
Lord.
2 Supreme Court judgments are relied.
Yes, this the matter as for orders in the কবে আনতে পারবে ওটা requisition?
Fix করে
As
নিন,
for
Mr.
orders,
Banerjee.
daily supplementary list of this court on 15th May.
15th
May.
Applies, my lord.
দু সপ্তাহ
My lord, may I take back the photographs?
These are treasured possessions of yours.
We have to engage laborers to clear the bushes and.
In the meantime, you have a conversation with your
My
officers.
lord, what is your lordship's mind? If your lordship will kindly indicate, my lord, we can.
We cannot say, because what is the practical situation? Irrespective of what are the latches of both the parties, he was enjoying an interim order. He was enjoying that order from 2001 till 2004. Now the truck is in such a condition. Now you cannot make a fresh valuation and provide. So 1,48,000 you have paid.
Yes.
To pay another 2 lakhs, finish, close the issue. We are not even saying 5 lakhs. The truck cost in 2001 It was a Jasushat truck. Substantial. Finish of the issue. The person. It was seized in 2001. Huh?
No, not 2001.
1998, right?
Yes, ma'am.
2000 তো সেখানে গিয়েছে। হ্যাঁ,
Pay 2 lakhs to him, finished.
We'll check.
Well, over here, it has to be a lordship's order.
No, then we will pass our order. It is not that we are, we can express things in our order. As you are appearing as an officer of the court, you have very fairly submitted that this is the condition. Because today the truck cannot be returned. And if you now assess compensation, it will be an astronomical figure. So your officers must also understand that. Then if not, let us see. On merits, we will
Yes,
pass
that will
order.
be good. Malar, I shall do my needful and
Yes.
express.
You cannot just bring the money and give it to me. It has to be a decision of the authority. Yes.
Grateful, Master.
Passed over method item 90.
CHAKRABORTY কি fix আছে দাও? Which pass over?
Item number 19.
What is that matter?
Here the petitioner is challenging the order passed by the single judge upholding the award.
Come tomorrow, let us see.
90.
Single judge's order was, award was confirmed.
Confirmed.
Since
Initially,
that you have come up in
Yes.
appeal. When was the single judge order passed?
the single judge passed an order.
This is the first time it is coming.
Yes, first time.
So there is a stay application.
Yes, the application 138 days delay in preferring the appeal by.
So you serve to file to the 30. Yeah, Mr. Roy, please.
Affidavit and of service is there. Initially award has been passed in favor of the company. They responded.
Serve and come. You serve and come.
Yes, we have already served.
You have served.
Yes, and
Is your other side.
Bolaram, Mr. Bolaram passed.
Was there any order of this is a 2022 appeal?
Yes,
Order.
13 May,
There was no order to serve.
initially matter has gone before before Honorable Acting Chief Justice and Justice Hiranmoy Bhattacharya. On that ground, the matter was released.
No, there was any order towards service where there is no order.
No order of service, but upon service, we have mentioned the matter.
I see. How many days delay?
138 days delay.
Then who is the advocate appearing?
Mr. Bolaram Patru.
Get hold of him and come. Otherwise, you have to serve afresh. Can 2 is an application for condonation. Can 1 is the stay.
Dear Lordship, kindly direct us to
Serve.
serve and to come.
There is a defect.
এই 400 টাকার নোট সিকিউ কি স্ট্যাম্প সাবমিটেড অ্যাট
Defect আছে, 83 days. Who was the writ petitioner? Writ petitioner was
Eastern Coalfields is the yes.
Lokhan Bhuiya.
No, Lokhan ECL is the writ petition. Initially, ECL has filed a writ petition. Initially, order has passed in favor of the ECL. Here the respondent employee is an unauthorized absentee. There, respondent employee was dismissed from service. He went before the tribunal. Tribunal upheld the decision of the company. Thereafter, respondent workman challenging the award came before this honorable court. The honorable single judge directed the tribunal to reconsider the issue, whether the quantum of punishment is commensurate with guilt or not. Thereafter, tribunal has totally 180 degrees turned around and passed an order. You reinstate the person along with the entire back wages. Challenging the same, the company has come before this court and the Learned single judge has uphold the second decision of the tribunal.
Contempt filed. Contempt has been filed.
No, till now, no contempt has been filed.
Who is the workman is that workman is Lakshman,
Lakshman Bhuya.
and who is Koila Mazdoor Congress?
Well, the union of the
They were represented. They
no, the workman himself is represented.
অন্যদের করে আর কি করবে? Did they contest? They did not contest. No?
Workman himself has contested Mr. Balaram Patra along with Mr. Rononesh Go Thakurdar.
Given copies to him.
Yes, yes.
Given
Yes.
Sampath.
Yes, yes.
Then give a notice to Mr.
Yes, your lordship passed.
And come back.
Your lordship passed the order. You will again serve.
No, you give a notice.
Upon notice, they have mentioned the matter. They did not turn up. Your lordship,
Matter will appear on Monday. You go and tell him it will be there in the list. Otherwise, we have to give fresh direction for service upon all the respondents. That will that we will consider. If he appears, then it is okay. The person appears, you consider your section 5 and yes, Monday rekhe that. You inform Mr. Balaram. I'm sorry. এই এটা দিয়ে দাও ওনাকে দিয়ে দাও
The state was represented. And we said that so far the claim of the petitioner is concerned, your lordship can release. I raised that interest to be, my lord, paid. I submitted an order in the before this honorable court in connection with the identical matter, also interlinked with this matter, that 8% interest was given by the honorable court. Thereafter, your lordships directed the learned advocate for the state, my lord, at least the admitted amount to be disclosed in a report, and the state is, my lord, obliged to submit the report, my lord, before your lordship.
Yes, my lord. My lord, may I hand over the report and thereafter explain the report, my lord?
But you have quantified any?
Well, I have taken the instructions, my lord. My lord, what appears is that, my lord, a brief background, my lord, on inspection, it was found that the petitioner had stored, my lord, this paddy, which is rice, my lord, rice, which is not good for human consumption. So, my lord, accordingly, my lord, proceedings were initiated. My lord, the not fit for human consumption rice, my lord, was removed, and my lord, it was sold as cattle fodder, my lord. Now, my lord, that, my lord, did not fetch the amount for which the rice was priced. The petitioner has also put in, my lord, this quantity, what was, my lord, found in the petitioner's possession was 746.7 metric ton. Now, my lord, this is priced at 1 crore 65 lakhs odd. Now, my lord, the petitioner has deposited 90 lakhs, which amounts to only 40 metric ton, not the entire of it. And, my lord, the remaining amount, which was sold as cattle fodder, has fetched 36.23 lakhs. Therefore, my lord, the actuals have not been, my lord, recovered from the petitioners. My lord, that is why, my lord, there is no admitted amount as far as the petitioner is concerned. The petitioner's case is that I have deposited some penalty. So, therefore, the admitted payments may be given to me. Now, my lord, since, my lord, the entire amount could not be realized because the petitioner was storing this rice which was not fit for human consumption, my lord. My lord, there is no admitted amount at all, my lord, in our calculation. My lord, that is what the report says, my lord. May I hand over and thereafter place the paragraphs?
My lord, what my learned friend has, my lord,
so since there is no admitted amount, my lord, now the order has to be, my lord, tested, my lord, on merits, my lord. Because the honorable single judge has held, my lord, upon looking at these facts, we had filed affidavits also, that there are disputed questions of facts which requires oral evidence, which cannot be decided in the writ petition. Can seize the facts, my lord, and thereafter, my lord, if your lordship feels, my submission will be to hear out the appeal on merit.
My lord, may I submit to the my lord submission to of my learned friend. Rather, entire thing was my lord placed in a confusing manner because the petitioner never supplied any my lord rice unfit for human consumption. I will show from the record itself, from their documents, how it was held. My lord, while the consideration of payment of 2014 and 15 Kharif season, which is the subject matter of this my lord writ petition, my lord, was pending. That time a report was submitted to the CSC MD, my lord, that you stop payment of Hasina Banu rice mill. That's the letter. But my lord, from the documents they have submitted, my lord, I will show that no proceeding was initiated, no show cause was my lord made against the petitioner, no supply was my lord seized as a sample, nothing was done. Even the officer who is responsible for this incident, my lord, he was even exonerated. My lord, that is the thing. I will show you, lordship, that this amount has been, my lord, an admitted amount, and that they have stated in their affidavit in opposition. They have not denied. They have stated that paragraph 1 to 17 are matters of record.
My lord, in paragraph 11, your lordship will find that we have already taken disciplinary action and punishment has
my lord, given. Why this matter, my lord? I showed your lordship.
Not right that the person was scot-free. My lord, disciplinary proceedings were initiated and punishment has been.
We have to hear it on merits.
Yes. My lord, report, my lord, I was only trying to praise to show that there is no admitted amount, my lord, on this limb of the submission. Yeah, I'll give it. I'll give it.
No, do you, this report has not been referred to in your opposition to the.
No, this is only, my lord, in the appeal. My learned friend initially, till today, has restricted the submission that I have paid some amount as penalty. Therefore, the admitted amount.
Then in a similar matter, identical matter, where I was the Miller, there 1 crore 18 lakhs equivalent to the cost of that rice, inferior quality of rice, that was deducted. What my learned friend is saying, 90 lakhs was deducted, part payment was deducted. All these are out of record.
Mr. Roy, then you.
Then, my lord, this report is not needed.
It's a synopsis which has been given. You go through this synopsis because he has come on the basis of this is in fact an instruction given to the advocate.
Well, that they got the instruction that submitted before your lordship. Your lordship, I have handed over him the order of, my lord, 1 minute. I have handed over to my learned friend for, my lord, not to harass the petitioner, but to do something fair. And I handed over the order passed by the Honorable Chief Justice in Bhaspara, SKUS Limited, where, my lord, I have indicated him, I have shown him that the quantity which was reportedly of inferior quality of rice, which was supplied in the year 2013 and 14, that amount was deducted from the claim of loss per SKUS. And I personally handed over the document.
I don't disagree, my lord, but
connection with a separate supply.
Well, no, that means to be supply, not separate supply. And my lord, there is no evidence, proceeding, my lord, against me, alleging the supply, my lord, of inferior quality. Against this, who is suffering since 2012 for the arbitrary action. And this is a payment relating to the Kharif season of 2014 and 15. The payment towards the Kharif season 13 and 14, they are paid on the basis of the inspection report, the analysis report, everything. And so far 2014 and 15 is.
Mr. Roy, the case was that 2013, 14, 15 Kharif crop levy rice. Pertaining to that, you supplied, they analyzed it, analysis report was in your favor and everything. It is on the basis of a show cause issued pertaining to another go down.
Show cause was issued to me.
The officer concerned.
Right.
You have the issue show cause to you. You
Right.
are a licensee. You are a contractor.
Yes, I am a supplier.
Basis of a show cause notice which was issued
Right.
to one Pradeep Chakraborty.
Right.
That issue, according to you, was relating to a separate go down,
Right.
which has no connection with your.
Right.
This was your context.
Right.
you brought this on record and they have filed an affidavit in reply to the same.
My lord.
Mr. Bandyopadhyay, can you come to page paragraph? There is a statement you have made. We have to.
The opposition is at 103, 103.
Not the opposition.
My lord, kindly come to the opposition paragraph 110. 110. Entire contention of my writ petition was dealt by them.
110.
No.
110, there are not so many paragraphs.
Yes.
Page 110.
Page 110. Affidavit in opposition, inner page, my lord, 8, my lord. May I read, my lord?
No, then you argue, Mr. Roy, because we have to hear it.
My lord, that's true. But my lord, let me submit that with reference to paragraph 1 to 17, where my entire case has been, my lord, reflected of the instant writ petition and paragraph 1 to 5 of the said supplementary affidavit. It is submitted that the statements made there are mostly matters of record and deserve no comment. That means the work orders are admitted, the supply was admitted, the inspection reports, analysis report, everything, specification of the, my lord, the quality of the rice was admitted. So, my lord, the bills were admitted. Then, my lord, how could they say that, my lord, they have supplied the inferior quality of rice, so she is not entitled to any payment? And they have come before your lordship. I'll show your lordship. This is a bold statement, contrary to record. Even I supplied the order of the Honorable Justice, Chief Justice, my lord, to my learned friend. He has not gone through it. He has not advised the client that you see that the amount of 1 crore 18 lakhs was
taking submissions.
1 crore 18 lakhs was credited against 746 of metric ton.
Communicated with my client.
Just a moment.
But he is
We what good, bad, indifferent, they are not settling the matter.
My lord.
So you contest on merit, you are.
My lord, your lordship also can do one thing, my lord. In the similar matter where, my lord, the amount.
A question came up that whether we can refer the entire matter to the director of
My lord, my lord, your lordship, kindly see the similar order in the context of where, my lord, Hasina Banu was, my lord, the rice miller, the Honorable Chief Justice, because they have not consulted the record, my lord, properly. And that's why this had happened. So, my lord, if your lordship keeping pending the
your purpose.
My lord.
Because this matter has to be hard on merit.
My lord, my lord.
Delegation to the authority, they will.
No, my lord, because they are, however, for any reason, they are not, my lord, conversant with the latest development. So if your lordship keeping this pending, giving fortnight's time to the my lord, district controller food and supply, my lord, to.
Has any new document come into play?
My lord, that is the, my lord, order dated 5/9, my lord, of the MD, my lord, the ECSC, which I have submitted before your lordship on the other day. That is dated 5/9, my lord. On the other day, I submitted the document, my lord. If your lordship goes to the last portion of the order, my lord, where from your lordship would found that the quantity is, my lord, same, and the amount against that quantity was deducted, already deducted. That has not taken into account.
This is not a part of your affidavit also, Mr.
My lord, not part of the affidavit because that time it was not disposed.
Then bring it on record.
My
You
lord.
can deal with it.
My lord, my lord,
File a supplementary.
my lord, my lord, my lord, my lord. And my lord, your lordship can, my lord, also,
It was also not before the honorable single judge.
my lord, your lordship can also refer this matter to the district controller, my lord, for an alternative dispute resolution mechanism, my lord, because I can satisfy him, I can show him that this is the amount already you have deducted. So far this 14-15 bill is concerned, my lord, there is no dispute.
Do you want to use any further opposition to the stay application?
My lord, if new documents which were not before the honorable single judge,
We are saying that your affidavits in the writ petition are already.
my lord, if the matter is taken up, I'll use the affidavit to the stay application. My lord.
So then do it. In course of hearing, Mr. Royal and advocate appearing for the appellant prays for leave to file a supplementary affidavit to the application for appropriate order being Can 1 of 2021. Stop. Let such supplementary affidavit be filed within a week with a copy to Mr. Bandopadhyay, learned advocate appearing for the state respondents.
Yes, my lord, only one line objection. My lord, it's a new document not before the honorable single judge. Honorable single judge did not.
My lord, this is a part of the adjudication of a
Appearing for the state respondent. The respondents would be at liberty to file an affidavit in opposition to the application for appropriate order. Would file an affidavit in opposition dealing with the averments made in the stay application as well as the made in the stay application and the supplementary affidavit. Stop. Reply thereto if any be filed. কত বলছো এটা তো সাপ্লিমেন্টারি তারপর handed over to Mr. They would get liberty to have opposition dealing with such and such within 2 weeks thereafter. Stop. Reply thereto if any be filed. 2 weeks কত চলে vacation এসে এক সপ্তাহের ভেতর vacation এসে Please the matter for further consideration in the daily supplementary list of this court on 8th.
On 8th,
No,
In 2 weeks, there.
Reply thereto if any be filed within 7th June.
No, matter 7 June.
No, ওদের এক সপ্তাহ বলছি তো 25 আজকে 25th. 1 week will take us to Tuesday. In 2 weeks will take us to 16. Date type or affidavit in opposition within 8th May. ওরা তো 1 week বলছে।
If your lordship is keeping the matter in June, kindly gives me till 15th or 16th of May.
Supplementary affidavit within 4th May.
My lord.
Stuff. Opposition by 18th. Reply thereto by 7th. Please the matter for in the daily supplementary list of this court on 12th of June.
My lord.
Is there any other respondent? Only state.
Lord, may I take back the lord
Yes.
order so that I can
Return
next
one.
week.
Which one? This
Lord,
order.
that,
Order.
this one.
Do you want to take back this
Well,
sheet also?
I will bring on record.
Yes, you can bring it in this supplement. You gave us 2 copies. You can take back your other copy.
তুমি আমাকে দুটোই না একটা কপি তো দিয়েছো আমি দুটো কপি নিইনি my lord this is the copy actually submitted by him my lord this has come
The report to district.
No, not this is instruction to the lawyer. You use your opposition. We will.
Get
You
fully
need
lord.
whatever.
Then, my lord, it's not required to be served on my learned friend also, my lord.
No, not required, Mr. Because that is.
My lord, otherwise how can I deal, my lord? Because
ওটা deal করতে হবে না।
it was placed before your lordship so that I can see what they're saying.
That
Because-
they will enclose in the opposition which they are going to fight, if they so desire.
No, if they,
If they do not bring, that will be without records. We will consider on the basis of the records. Yes.
my lord, let me check and hand
No,
it
no,
over.
please give it back. The court is not taking notice of it. Don't
No, court,
kiddish.
you have submitted before the court.
And court has returned it.
Yes. কোন ম্যাটারটা আছে? দেখে দাও, দেখে দাও।
এই বান্ডিল বান্ডিল বান্ডিলটা বলেন
the copies of the judgment? 2006, volume 3, 7.
All the
volume-
judgment I have cited, I have already handed over to my lord. Again, my lord, I will prepare a short note for your lordship's convenience and annexing the judgments.
When you have given it, why should you give it for 2 times? কোথায় গেল?
For handy purpose, I will with your lordships.
All right, yes.
Now, my lord, may I just, after a gap of some days, let me recapitulate the points I have raised. Now, this is an appeal against an order by which suit has been dismissed by invocation of Order 7, Rule 11, suo motu.
Yes.
While deciding my application under 39 Rule 1 and 2 in a partition suit, the court proceeded on the basis that you have no case in the suit. And ultimately, it has been stated by the learned judge that I am invoking my power under Order 7 Rule 11 and dismissing your suit, not dismissing the plaintiff.
Yes.
This was my first submission. I submitted before my lord. My lord extensively had taken note. But I am not questioning the power of the learned judge of invoking Order 7 Rule 11 suo motu. I am not questioning. He can. But exercising power under sections Order 7 Rule 11, he cannot dismiss a suit. He can only reject a plaint. Here, my lord, my suit has been dismissed. The language used in the penultimate paragraph is suit is dismissed on merit.
You have shown us that.
Only just recapitulate. My lord, my first submission before my lord, while deciding my Order 39 Rule 1 and 2 application, not only my case, defendant's case also consider. While considering the defense case, he said that my injunction application is dismissed. He could have stopped there because he has considered my defense case also. And go on commenting that this is the case, yours, this is the case of defendants, you are unable to prove your case. At a stage when there is no issue frame, far less to speak of any evidence, the action has been started. Issue has not been framed. At an interrogatory stage, plaintiff's case is there, defendant injunction application opposition is there, and court has gone on commenting that this is the case of both the parties, you the plaintiff unable to prove your case. My submission is, my lord, court is preempting. At a stage when issue has not been framed. And I have cited some judgment for your lordship consideration that invocation of Order 7 Rule 11, you cannot look to any other document excepting the plaint, meaningful reading, and the document annexed to the plaint. And your lordship's court judgment categorically said, you, for the purpose of invoking Order 7 Rule 11, you have to consider the statement made in the plaint as true. What is my plaint case? In paragraph 2, I have said, I got married with Rana Safui under the Special Marriage Act, and this is my registration certificate under the Special Marriage Act under Section 13. So at that stage, none to dispute. Coupled with the fact, if I have placed before lordship the Special Marriage Act, is an elaborate procedure laid down how it has to be done, the solemnization of marriage and how registration has been done. There are 3 stages where you have to publicize, public notice, and thereafter the registration is concluded. And the subsection 2 says this is a conclusive proof of the marriage. This is the conclusive proof of the marriage. My lord knows the Evidence Act come into force, none can rebut it. But probably my lord has taken note of the Evidence Act also.
That you have placed.
If it is conclusive proof, my lord, lordship is every day doing land acquisition matters. Section 4 notification, Section 6 notification is a conclusive proof of the, my lord, public purpose. No one can. At this stage, when the plaintiff only is before the court, exercising order 7 rule 11, whether court can say, ask the plaintiff to prove his case on that date. According to my humble submission, it cannot. Now, my lord, this is so far as order 7 rule 11 is concerned. He cannot dismiss my suit on order 7 rule 11. He at best can reject my case under order 7 rule 11. Plaintiff can be rejected. I have cited one judgment, my lord. Probably this is the only judgment I could lay my hand. What the distinction has been made, what is dismissal of the suit, what is rejection of plaintiff. So here, my lord, the court itself has recorded, I am dismissing your suit on merit. By invoking order 7 rule 11, both cannot go simultaneously. My second line of argument was there that if my registration under section 13 is a conclusive proof, my lord, who can challenge it? My lord, section 23 of the Special Marriage Act. No, for section 24. 24 Special Marriage Act elaborated the grounds of void marriage. One of the ground is subsisting of a valid marriage. If you are solemnizing marriage during the subsistence of the marriage is void. Section 24 contemplates that these can be challenged by the parties to the marriage by a application filed therein. So means by a suit, and that too by the persons who are tied the knot, the husband and the wife, none else. If that be so, this safeguard is there, whether a court under order 7 rule 11 stage, without any application, without any suit being filed, can declare that the marriage of my client is void. Subject to correction, my lord, it cannot. It has to be presented by a suit. Now, the statute says, section 24, that it is a parties to the marriage can file a suit. But I have cited one judgment, but probably this is a solitary judgment in this point, where, my lord, it has been carved out little. What is the carving out? If your right of property is affected, you can file a suit for dissolution of the marriage. So you have to file a suit and to justify that the marriage is invalid on the ground the subsisting of the original marriage. There, my lord, I have so many defense to, if that suit is filed, I have some defense to be made there. So because that is not the stage, you had not to deliberate on that issue, because stage has not come, no petition filed, no suit filed, declaring the marriage of my client is void. Yes. Now, on this ground, I have stopped there. Now, today, my lord, I am taking that I am satisfied with my case. If my lords are with me on that point, then, my lord, suit will revive. A partisan suit will revive. My lord knows what is the effect of a partisan suit. In a partisan suit, an injunction is on mere asking. Yes. Kindly take up the papers. Kindly take my application. Can number 3.
Application.
A can 3 around.
জন্য কি সেপারেট অ্যাপিল করেছে? কিসতে কি আছে?
না কনজয়েন্ট করেছে বলে। Only one appeal file.
Yes, yes. But if my lord not having the judgments, my lord will prepare as note and all judgments will be.
Oh, we have taken you. You have cited before 2006 volume 3,
No,
7 volume 3, 10 volume 4 MLJ, 23 1 CLJ, 27 SCC, and 1999 2 SCC, 1996 2 CLT.
23-1 CLJ of this bench, this court judgment.
Yes, yes.
Justice Chakraborty and Justice Basu Chaudhary.
Which volume you are asking us
No,
to?
kindly say 3. Kindly take the 3
Can 3 ta daw?
and 3. Length is also there, but I will be troubling a lot see for this volume, that volume. That's why I want to place it.
Can 3 ta?
Well, kindly, just is got in mind. Kindly come to 34A, the plaint. This is a suit for partition by my client as a plaintiff. Now kindly straight away come to the prayer in the suit. Page 42. Pages. Well, kindly may I read with my lord. Partition of all the properties left behind by the said deceased, including those mentioned in paragraphs such and such, plaintiff being the absolute owner, then is important, of 1/4 share of each of them. I am not claiming the entirety. I am claiming 1/4 share of the entire property. Initially, there was not all the properties in the hotspot of the partition suit, that was also brought. Now the suit is maintainable for bringing all the properties in the hotspot of the partition suit, and I am paying only 1/4 share of the entire property left behind by my husband's husband. On the basis of this plaint and the injunction application, the trial court initially passed an order on 23rd December 2019. My will get at page 161. What is it? Page 161. Apparently, it transpired that the plaintiff is the second wife of the deceased Rana Sapui. The defendant number 1 and 2 are the daughters of the said Rana Sapui from his first marriage, and defendant number 3 is the mother of the deceased Rana Sapui. The contention of the plaintiff is that the defendants, after the death of the Rana Sapui, have transferred or encumbered the properties of the deceased Rana Sapui without following the due process of law. It is further alleged by the plaintiff that the defendant have misappropriated huge sum of money from the bank accounts of the deceased Rana Sapui, as well as the transferred the fixed deposit accounts of the deceased in their favor. Having considered the entire aspects and plight of the plaintiff, it is seen that the right of the plaintiff has been infringed upon by the defendants. Therefore, in the given circumstances, if necessary order is to pass, certainly plaintiff would suffer irreparable loss and injury. Then, my lord, order is passed. What is the order? That the defendants, their men and agents are hereby restrained from alienating, transferring, encumbering the properties of the deceased Rana Sapui. The defendants are further directed to maintain status quo in respect of those assets and properties of the deceased Rana Sapui. So, entire assets of the Rana Sapui was put on hold. But if today my lord is with me, that the order of dismissal of the suit is incorrect, then my lord, suit will revive. And my prayer would be that along with the suit, this order should revive. But now, in the circumstances has been changed to some extent, I will place those also. Now, my lord, I will not be praying, I am candid before my lord. I will not be praying before my lord, the entire property should be on hold. Because my prayer is 1/4. I will be happy if 1/4 of my share is kept on hold, so that if I win, I will get something.
Differentiate this 1/4.
Now, I know that this is really my lord's question. So far as the properties which are in possession of the respective parties, that may be continued. That has been passed by the. That's why I don't want to the entire order which has been passed by the trial court, which in effect may be revived. I am not asking for that.
Of how many, what property?
They have said that. I am accepting that. They have disclosed those.
Oh, I see.
They have disclosed those, and I say I accept that. There is no dispute. And my lord knows in a property, if the property is ultimately I succeed and property is partitioned by myths and bounds, then my lord, my possession has to be kept as it is as far as practicable. This is the theory of partition. So in that score, my lord, I will be praying only for those order, because that order has been passed in this appeal subsequently by the appellate court. I am placing those. How the court, on the basis of the subsequent events, modified that interim order passed by the court will. Now, my lord, kindly come to page 162. Now in the appeal, order has time to time modified.
No, this was the order passed by the trial court.
Yes, 161.
That and what is, when was the suit dismissed? 28 April.
After long.
22.
22.
Well, kindly pardon me for repeating. I repeat, if the suit is revived, the interim order also has to revive.
Yes.
But
that interim order was the order initially passed.
Initially passed by the
However,
court.
you are only wanting 1/4 share.
But in a partition suit, I will not block everything, which I don't have any right. Why should I? 1/4, I have right, claim right. Apart from 1/4, I have no right, even if the suit succeeds. Then, my lord, kindly come to 162.
162.
The respondent number 1 claims to be the second wife of the deceased. The appellant alleged that the alleged marriage of the second with the first.
Oh, against that, the daughters and mother came before this.
Yes. Now that is modified. Respondent is a nullity. That point was raised. Having been constant during the marriage with the second wife. After hearing learned counsel for the parties, the interim order such and such is modified to the following extent. The appellant shall not sell, otherwise transfer, encumber, or deal with the property mentioned in paragraph 3A of the supplementary affidavit, affirmed by the Kirti Safui on 17th August 2020. There is their affidavit. The appellant shall be at full liberty to deal with the property as mentioned in paragraph 3B, C, D, E of the said affidavit. The appellant assured this court. Now, this is the point, my lord, I want to urge. The appellant assured this court that the EMI of rupees 153 to 156 per month for the flat mentioned in 3A of the said affidavit shall be paid by them punctually. But why this is a modified order. The property where I am residing, this is the property of the deceased. So this is the estate of the deceased, and the EMI will also come from the estate of the deceased. The dependent has not required to pay. If ultimately, my lord, what is it? My lord knows, I need not repeat. In the case partition suit, the court's duty is to preserve the estate till decision. My prayer is kindly preserve this property also. This is also the deceased estate. And they have assured that the fund will come.
So that has exactly been done by the order. Yes. Because appellant shall not sell.
Yes. So the preservation of the assets, the estate of the deceased. 173. Well, kindly come to then Now, my lord, in page 178, this is supplementary affidavit, where, my lord, what are the properties are lying with whom? The details has been given. Paragraph 3, subparagraphs. This is the affidavit. I am not disputing that. Paragraph 3 is subparagraphs. Your lordships can look, page 178. These are the properties lying with me. Yes. Now, my lord, this order was sought to be modified. ঠিক আছে, ঠিক আছে। আমরা হাসবো না, লসেরা নিজেরাই হাসবে, এটা তো ঠিক না। ইয়েস, বলবে না। My lord, seen that this is the assets, what this supplementary affidavit filed by them. Now, my lord,
This is the entire asset.
no, not the entire. In my name, in my possession.
3A.
Yes.
That is 3A.
3A, 3B, C, D, E, F, E. These are, according to them, these are the assets lying with me.
Oh, achha. But the court, while granting the injunction, restricted it to 3A only.
No, that is, my lord, 3A means EMI of the 3A.
Yeah, no, the order at page 163.
That is the 3A means.
Reservation was effected by modifying to the effect that 3A shall be enjoyed by you, EMI to be given from the estate.
Yes.
And the remaining ones are appellants will be at liberty.
Not injuncted, modified to that extent. My lord, the division bench has taken care of everything.
Yes, now the appellants would be at liberty to deal with the property as mentioned in 3BC, which is your.
BC is mine. BC is mine according to them.
দেখাচ্ছে কীর্তিকেই দিয়ে দিচ্ছে BCD ওর জন্য শুধু
Here, my lord, only court was concerned with the EMI so that this property does not wiped out from the estate of the deceased. Now I am coming to that. Now the bank account was, my lord, stalled.
So your argument is you want more than what was the protection given, or 1/4 will be more and above that.
I will be praying, my lord,
3A, B, C, D.
In law, the trial courts orders to revive. But in law, but I am not asking for that. In the change circumstances, I will not say anything which, my lord, according to the court, will be unreasonable.
No, we are asking Mr. Basu, is it your contention that since my suit will revive if we hold in favor?
Yes.
In that the partition property which needs to be preserved.
Yes.
But however, I am not unreasonable.
I will saying entirety.
I will not take the entirety, only 1/4. But that is include the flat and something else.
Yes,
what are those something else?
A, B, C, D. Subsequently, well, I will show to you, lordship, that has been given, injuncted by the court. I will so come to that. I'll come to that. But this is the order now. So they are directed to give the AMI. Now kindly come to this order was sought to be reviewed. Page 202.
This order of division means
to be reviewed
by them. Page
20. Of their review application.
This order was
চলে গেল করতে এসে গেছে প্রক্সি দিতে
এটা রিভিউ চেয়ে বসলো রিভিউ চলবে
only ground is that kindly open the bank account so that I can pay the EMI. As Manoj kindly got it.
Yeah.
204 Roman 7.
No, that review application was at their instance.
Yes.
That is page.
Page 201.
You are showing us the ground.
Now kindly on ground, 7. For that, the order dated 18th August 2020 passed by the Honorable Division Bench, the appellant have been directed to make payment towards the installment in respect of the property mentioned in paragraph 3A of the supplementary affidavit, affirmed on 17th August 2020, that's affidavit. The order dated 8th August 2020 passed by the Honorable Division Bench suffers from an error apparent on the face of the record. Insofar as it fails to exercise the order dated 23rd December 2019, insofar as relates to bank accounts and properties mentioned in Schedule C to the plaintiff, to enable the appellant to comply with the order dated 18th August 2020.
So what is this 23rd December? That is
Bank account was, yes.
Ordered in
Everything was told. Everything was status. That is at page 161.
161. That was on 23rd December
Right.
2000. Yes.
Everything was as normally in partition suit. Everything kept preserved. Now that was came in the way of complying with the order of this honorable court. So they prayed for a review, and review has been granted. Only that ground. Now, my lord, kindly come to 211.
Where other grounds were not argued at the time of.
Well, I not bother with this. But this was only the ground, and only this was modified.
Yes.
It starts, my lord, at page 211.
The
order
order in review.
Yes. And, my lord need not be troubled to the entirety. Kindly come to 213, internal page 3. Last paragraph.
Yes.
In those circumstances, we clarify and modify the said order dated 18th August 2020 by saying that the appellant shall be in possession of the properties of which they are now in possession. Now, my lord, 3 ABCD comes in. They shall also be entitled to run the business of the deceased, which they are now, and operate all bank accounts of the deceased, which they are entitled to operate. The respondent number 1 shall continue to be in possession of the properties of which she is in possession.
Then what is the meaning?
Meaning they will go on paying.
BCD
also comes.
No, we clarify and modify by
Yes.
saying appellant shall be in possession of properties of which
Appellant,
they
that is appellant.
Yes.
Yes, they.
We understand, sir. You don't have to repeat
No, no,
some
he-
amount of. Yes.
He's excited too much.
No, he's always excited. We have seen him.
We have seen him. In the circumstances, we clarify and modify the said order such and such by saying that the appellant shall be in possession of the properties of which they are now in possession. They shall not also entitled to run the business of the deceased which they are now running, and operate all the bank account of the deceased which they are entitled to operate. The respondent of 1 shall continue to be in possession of the properties of which she is in possession. So 3 ABCD comes in. Am I clear to my lord?
So the issues, the points which were missed out there has been
Now
reincorporated.
Because they are probably on that date, I was not there. It was in the mind of the court only that you pay the EMI so that the property can be preserved. Other points are missed out. Now that has been incorporated.
Yes.
So this was the today this is the order holding. When my lord is hearing the appeal, this is the order, interim order is subsisting today. Oh.
Yes.
This was the interim order which was subsisting on that date prior to dismissal of the suit. So now, my lord is hearing the appeal. Now notice has been come, my lord, kindly come to page 230.
One 425 lakhs
Yes.
total loan amount.
And EMI is 153.
Mr. Basu, please come back to page 213.
213.
In those circumstances, we clarify and modify the order dated 18th August 2020, that is page 162, wherein the court said that appellant shall not sell 3A, which belongs to you. However, the courts assured on the basis of an assurance given that they will continue payment of EMI.
Yes. Why?
Now
Preserve
review.
the property.
Now review. Now in review, court says we clarify and modify the order. So the parent order does not remain read to,
No,
has to be read with the clarification.
Yes,
What is the
yes.
clarification?
Not remain will not do. It has to be read along with the clarification.
So what is the clarification? By saying, so we are saying that appellants shall be in possession of the properties of which they are now in possession.
Yes.
There shall also be entered. Now, all bank accounts, response shall continue to be in possession of the properties. So you continue, pay the EMI, continue.
No. Kindly go to the grounds mentioned therein and release of the bank account. Bank account was sealed.
Then you ought to have taken a further application for modification.
Not
Because
necessary.
if this order remains.
Not necessary. If your lordship look to the what is the intent of the court, it is clear. If your lordship look to the order, look to the review application and the clarification, it
Ground
is apparent.
7. It was ground 7, page
Yes.
162,
It is
and
only
the order.
ground. If your lordship read 3 in a harmonious manner, it is only intention of the court is to preserve the property along with me. Just my lord was testing me.
Property. No, if we read it in a harmonious
Yes.
manner, harmonious manner will lead us to the conclusion that the flat will continue to be in your possession.
My possession and the bank account have released only for the purpose of giving installment.
That is your argument.
But that is apparent if your lordship is harmonious, the 3 orders.
All right. Which page you are next showing?
Now, my lord, 1230. Now they have not paid. That's why the notice has been given by the LIC Housing Finance Limited.
You were not there at that time. Matter when was review was hard.
I was a newcomer.
Yes. Yes. Anything else, Mr. Basu?
233 kindly come, the final order. Final 230 my lord read.
That
Now
is
kindly
the-
233.
That is the 13-2 notice.
13 to notice.
Now, what is the present status?
Present status, my lord, have not touched yet, not touched yet. My lords, kindly recall your lordship's observation that when the my lord is hearing the matter, they will probably not touch, not touched. But I am a precarious condition. Tomorrow I may be thrown out, defeating the order of the division bench. Now, my lord, I kindly once look to one order, that is the division bench was to send 235.
Oh, contempt was filed by you. After this contempt filed by you. Yes.
Well, kindly come to the page 235. Well, I have for placing or not placing, it is not the court said that contempt is not. I go and other court and file appropriate application. I am reading the page 236, internal page 2. The contention of the appellant cannot be decided in this contempt jurisdiction. Although we have observed that the possession of the plaintiff in respect of 3 flats would not be disturbed, but we have not passed any order recording any undertaking that the alleged contemptor would continue to pay AMI per month, as observed by the earlier division bench in disposing of the appeal on 18th August 2022, as modified on 9th October 2020. The effect of non-payment of EMI by the respondent may affect the possession of the appellant, but in absence of any specific order to that effect, it cannot be said that the contempt respondents have violated the order. I was not there. I should have not advised them to file a contempt. In view of the fact that especially we have not passed any such order, and the contempt jurisdiction should not be exercised unless the court comes to a satisfaction at the time of issuance of the rule that there was any prima facie violation of the order. Rules should not be issued as a matter of course. It may be true that by non-reasonable non-payment of EMI, possession of the plaintiff in respect to 3 flats may be precarious, but in contempt jurisdiction, we cannot go into such aspects of the matter as we have not specifically recorded any undertaking from the Sapuis with regard to the payment of EFI. However, this order shall not prevent the appellant. Now, the court was very much concerned that non-payment will be a precarious condition for B, but court's hands are tied in contempt jurisdiction. This was not.
Where is the 11th May 2022 order?
That is a 226 order.
226.
Yes. This is while admitting the appeal, my lords. No question of admission, first appeal, but this order was passed.
No, prior to this, the interim order was modified.
Yes.
Okay. Then came the contempt.
Contempt.
Alleging violation of order,
The order of
dated
the
11th of May.
contempt jurisdiction should not have been invoked. Because
what has been stated here in 11th of May, their lordship says that we are recording.
Where my lord is reading at
page 226.
226.
We admit the appeal and grant stay of operation of the deemed decree. That is order 7.
Order 7.
Oh, this is the appeal against. Oh, this is the appeal against.
Now my
rejection
lord
of-
is hearing.
That is rejection of
Dismissal
dismissal
no.
of suit. Dismissal of suit.
Not
Yes.
rejection of claim.
We corrected ourselves. Sir. Yes. Now, what has happened to the other appeal in which this order initially was passed? That was passed in this connection. Page 162.
Just
This
a
is
minute, let me
FMAT
check up.
67. This was a
That appeal-
separate appeal against the
Disposed of.
interim order.
Their appeal at interim order disposed of.
Oh, that has been disposed of. Where is the disposal order?
বলতে পারবি 160 তে disposal হয়ে গেছে।
So that order has attained finality then.
Yes,
Reviewed order
160
has
disposed of.
attained. Oh,
Disposed of. Appeal and the connected application are disposed of.
page 150.
163.
Oh, acha.
Initial
Oh,
order,
I-
the appeal and the
oh, acha, acha, acha. Just disposed of.
That's why review. Otherwise, could have been recalling application. I missed it, man. I read. Miss করে গেছি, dispose of.
We have heard the council. We has made a
Hey, come to the last page, page 2,
Order 7, Rule 11.
last part of one paragraph.
তাহলে আর আমরা order 7 appeal admitted হয়ে গেছে। Order 7 rule নিয়ে appeal যেখানে admitted হয়েছে, হয়ে গেছে। ওটা কিছু করার নেই। ও তো যদি contempt
এটা তো মডিফাই হয়ে গেল ওটা, ABC এসে গেল তো ওটাতে মডিফাই।
না হচ্ছে সৌমেনের যে অর্ডারটা যাতে কন্টেম্প হলো 26 অ্যাপিল অ্যালাউ করলো, সেটাতে 227 আমার পজিশনটা 3 প্রপার্টি রেখে দিয়েছে। সেটা ডাইরেক্ট বলি যখন কন্টেম্প ওই কথা বললো 226 এ এই অর্ডারটা এখানে রেখে দিয়েছে, এই যে 227 এ যান এখানে এইটা লিখে
Order 7 rule 11 of the rules. Injunction and issued as in final disposal of disposal of should hold suit যদি revive. Yes, Mr.
No, okay, my lord has now on 227 page.
Yes, yes.
Kindly see, my possession was also in this order, while admitting it, this is also kept reserved. In view of the admitted fact, the plaintiff is presently in possession of 3 flats. The possession of the plaintiff should not be disturbed till the disposal of the appeal.
You are in possession of 3 flats,
Yes.
not only that one, 3A.
Affidavit A, B, C.
Oh. 3, the EMI is pertaining to 3A.
A.
Achha.
So in this order also, my lord, my possession was kept reserved. Till today,
No.
that order is there.
Kept reserved in respect of 3 flats.
Yes.
That is B, C, D.
3A, B, C.
There were that application you showed
Just
us,
a minute,
page 161.
Supplementary affidavit. 173.
Sorry, 170. No, page 178. 3A was triplex apartment.
Yes.
3B was
That is the
Central
EMI.
Road.
That is the EMI.
EMI. 3B is Central Road flat.
Yes.
And
3C
3C
is Central Road flat, another flat. And D is garage.
garage pertaining to Central Road or garage pertaining to triplex. We do not know. As a jewelry.
These are the. So ABC was preserved. A is with EMI.
Yes.
My lord has now seen, my lord, the 13 notice. My lord has looked to that. So, my lord, now my condition is that if your lordship is with me, that suit is revived, then my lord, I have to be protected. My client has to be protected. Why, my lord? Otherwise, the situation will be irreversible. I'll cite 2 judgment for your lordship consideration to conclude it. But kindly take trouble to see AIR 1983 Supreme Court 742.
Now, so Mr. Basu, your possession in respect of 3 flats have been protected
Today, today protected except one is
till the disposal of the appeal.
appeal. Today, my lord is disposing of the appeal.
So you are now praying that in addition to that, now pay EMI.
Yes, because EMI also directed.
Because that was direct.
Directed.
The 1983.
1983 Supreme Court. এই কোনো করিস না মহা মুশকিল।
AIR 83.
AIR 1983 Supreme Court 74. দে
742.
এটা আপনার কত? তোর আমাকে পড়তে হবে আমার। Kindly come to paragraph 6. 6 starts with in AIR. When an interim injunction is sought, দেখ মেলা ঠিক আছে but can you read that 6 kindly come, not to read entirely, kindly come to the middle portion. Similarly, we are of the opinion that if respondents are allowed to put up construction by the use of the FSI for the whole of the land, including the land involved in dispute, the situation may become irreversible by the time the dispute be decided and would preclude fair and just decision of the matter. So if your lordships don't protect me, ultimately if I succeed, I will not get anything, only the fruit of the judgment I will not get. My lord Mace,
BC তিনটে ফ্ল্যাটের মধ্যে একটা ইএমআই নিয়ে গন্ডগোল, সেটাই তো যন্ত্রণা।
আমি তো করবো গাড়িটা
রিজার্ভ করতে চাইছে প্রপার্টিটা, ও ইএমআই দেওয়ার থেকে ওরা
তোকে ডাকে এবার
রিজার্ভ দিয়েছে। ওরা বুঝুক এত টাকা ইএমআই দেবে।
ব্যাংকে ওই টাকাটা পুরো টাকাটা এখন আছে অ্যাভেলেবেল
পেয়েছি, ওদের সুবিধা
হ্যাঁ
দুজনকে তাহলে
নিশ্চয়ই বলবো।
Relatively exist as the estate of the deceased.
না এক্সচেঞ্জ হবে আনতে হবে
ব্যাংক অ্যাকাউন্ট
2004 volume 8 Supreme Court cases 488 paragraph 10
2004 volume 8
SCC
8 SCC
488
488 paragraph 10.
very short judgment my lord. It's actually like this. Starts with be that as it may. Be that as it may, Mr. Sachar is right in contending that unless and until a case of irreparable loss or damage is made out by a party to the suit, the court should not permit the nature of the property being changed, which also includes alienation or transfer of the property, which may lead to loss or damage being caused to the party, who may ultimately succeed and may further lead to multiplicity of proceedings. In the instant case, no such case of the irreparable loss is made out, except contending that the legal proceedings are likely to take a long time. Therefore, the respondent should be permitted to put the scheduled property to better use. We do not think, in the facts and circumstances of this case, the lower appellate court and the high court were justified in permitting the respondents to change the nature of the property by putting up construction, as also by permitting the alienation of the property, whatever may be the condition on which the same is done. In the event of the appellant's claim being found baseless, ultimately, it is always open to the respondent to claim damages, or in appropriate case, the court may itself award damages for the loss suffered, in, if any, in this regard. Here is a case not of partisan suit. This is not a partisan suit, a C performance or something like that. In a partisan suit, well, but here is a partisan suit. Your lordship knows partisan suit. We are asking, injunction is granted. But I am asking an injunction against me also. Restrict me from alienating or transferring the property where I am now, and also to the same, because the endeavor of the court is to preserve the estate of the deceased. If my lords are with me, so far my first part is concerned.
Yes.
So that's all, my lord. Should I put a short note for your lordship's convenience?
So, Mr. Basu, suppose if it is protected, EMI is to be paid by them, everything done in your favor. Even if they succeed in this, they won't be able to evict you therefrom.
Why not? Why not? If my right goes, I'm a trespasser.
Trespasser has to be removed, but in accordance with law.
In accordance with.
If this court finds,
We think,
yes,
I
we are
am
thinking
just,
aloud.
just thinking that what is the reason for them to say that you enjoy, but we will not pay the EMI.
That is my lord. My lord can well understand what is there.
No, but Mr.
I know,
Basu, you have two other flats.
Yes.
To leave the flat, let them, we will ask we will hear him as to what is their plan as regards that flat.
But can they now say, till my suit is there, they cannot claim, or I cannot claim?
No, that is if
I
you
have
hold
right
in
in
your
every
favor.
every property. If unpartisan property, if ultimate till it is decided that I have no right.
We are not on that issue, sir. We are asking you. We are just asking you. Suppose what we understand is, if it revives, the interim order revives. Now, what will your grievance is that there was an assurance given. Let them pay that amount. It will be estate of the deceased. It will continue.
Along with that, my right of remaining there is protected by your lordship's court. Times without number. At least twice your lordship's court has.
So that is protected, but question of EMI is not protected. That is protected. You enjoy, pay the EMI.
This is my lord taking away something by giving something.
So exactly that is what we are wanting to curtail the litigation today.
But they are not paying from their own pocket. This is coming from the estate. And in estate also,
so you hand over the possession to them. They will pay the EMI. Let them.
Protected by your lordship.
You are protected by two flats are already there.
If my suit succeeds, I have right in every property.
You will have right.
Maybe more.
You will have right if this modification is made. You continue to be a co-sharer in that property as per your argument.
What they will gain? If they will
Gain
not
or loss, we are not. Are you accepting such proposition?
Because I am deciding that with my husband. That I have some sentimental value. Ex-husband.
Unfortunately, the husband is not there now.
I have sentimental value there. If ultimately my right goes, sentimental will not do.
Your right will never go, Mr. Basu. If we revive this.
Till such time the participants to revive and my right is there protected till decision. This sentimental value is attached to this property also.
So you are not inclined to that. So your sum and substance of your argument is that dismissal was that has to be revived first. Second, upon revival, partition property, court has already held in my favor that 3 flats I will possess. Only what remains is the limb attached to the
undertaking given by them.
That your argument is that everything is all right. You revive the suit, injunction will come in my favor. But as there was an assurance spoken before the court, estate of the deceased, let them put in the EMI. This is your argument.
So nobody has right today.
So you hand over possession, forget about the Securitization Act and everything, live peacefully in your 2 flats.
No, then my lord, the property, estate property will be ruined.
How, Mr. Basu?
Because if the EMI is not paid from the estate.
That we will ask him.
What I'm thinking, my lord, if the proper EMI is not paid from the fund of the estate,
yes,
then the property will go beyond the estate.
No, that is your anticipation. We know how to impose the safeguards to protect that.
If the EMI is paid, I will be not the owner. If the EMI is paid, I will not be the owner.
Bone of contention is there is a hatred in between the parties.
Otherwise, why will you come to court?
No. Why? Court doesn't mean that there has to be. So we are to cut short the litigation.
I am
So
agree.
you hand over the flat, forget about securitization, everything, and we will ascertain whether they will be preserving that by paying that EMI from the estate of the deceased. Or
This
not.
is the order. Kindly recall the review application. The estate's bank was seized. That's why review application. Estate banks, nobody's personal account. This is husband's personal account. Accounts was seized by the court. Status quo. That's why the review application made. This is not their personal account. They are not paying from their personal account. Whatever EMI, whatever expenses coming from the estate.
Where is that bank you said? Bank operation, what you said?
The entire thing was stalled.
That was the 2019 order.
Then, my lord, this the honorable court,
Modification.
why the review? Review is for that purpose only, because they are unable to operate the bank account.
Is it?
Altogether 17 bank accounts are there. Joint account is ঠিক আছে.
They are operating all that. They shall entitled to run the businesses of the deceased which are
All that they are doing. Today I am not asking for, because under law I have a right in every inch of everything of the disease. To that extent. So till that time, let the property be preserved. Maybe I am in possession. Let property of the estate be preserved. That's all.
Thank you.
Could I just start with what I heard last? Under the law, I am entitled to have every right in every inch of the estate. Two things, my lord, if I could just indicate. Firstly, this estate that is being made out by the plaintiff appellant. This is not a trust. It's not a debottor. It's my father's property. X files a suit claiming to be my father's wife. Impledes my grandmother, impledes the two of us, keeps the legally wedded wife, my mother, outside the suit. The entire plaint is cast on the basis that she is 1/4 legal heiress. She is my father's wife. My mother is, and one thing I'll indicate, because this is one 28-year-old and one 21-year-old girl who I have this conference with. It's not so much about the estate. It's not so much about this relationship that your lordship find, that your lordship opine. The question is, who is my mother? And who is my father's wife? That is the question here. Otherwise, this kind of relationship would not have come in. Who is my father's wife is the question. And that is my specific instructions are to address your lordships on that, because that is what they want to salvage themselves from. Who is my father's wife? There's a lady who files a suit claiming to be my father's wife, impledes my grandmother, impledes the two of us, does not implead our mother, claims that she is a legally wedded fourth legal heiress. That is the foundation of her claim in the plaint. And in that, she has schedule of the plaint is every bank account, every scrap of paper, every LIC policy, anything that stood in my father's name. Why? Because she claimed to be my father's wife. Suppressing two facts. One, that she was herself married. But it's all fair to come up before your lordships and say that learned court below has gone wrong. Learned court below has painstakingly looked at every document which the parties wanted the learned court below to look at in course of an injunction application hearing. The plaintiff.
What were the two suppressions?
Two suppressions. One was that she was herself married. She could not produce a scrap of paper that is valid in law to show that her marriage was also dissolved. She is a married lady admitted. I'll show those pleadings. Second, so much about the marriage certificate. It's a forged document. Admitted. That also I'll show. We've heard arguments on Section 25 and the import of the Special Marriage Act.
I'll show there's a document on record to show that there is no such marriage certificate lodged in the registrar under Special Marriage Act. That has been dealt with by the plaintiff in its affidavit in reply, saying, I don't know. I believed the same to be true, but if it has happened, then fault has been laid on me. Third, that she was married, according to her, during the subsistence of the marriage between my parents. My father and mother were married when this lady claims to be the married wife of my father. This first part of the story was also suppressed. When we brought it on record, she said, well, we were not told by my ex, the man. So and complete turnaround. And please, I do not rely on me from what I'm arguing. If I don't back it up with documents here, your lordship will impose cost on me. Everything that I'm saying, she turns around and writes, Rana Safui has played a fraud on me by making me believe that I was married to him while his first marriage was divorced.
Mr. Banerjee, you argue on the points.
Yes, my lord. And one more thing, my lord, the written notes of arguments, your lordship, the argument was advanced. The learned court below changed track on his own from legally wife to concubine. Your lordship will call upon the plaintiff appellant to produce the written notes of arguments that they had supplied before the learned court below. The written notes of arguments was cast on the basis that she has become a concubine. Your lordship will call upon that document. It was written notes. It is on the written notes of argument the learned court below proceeded. Because that was the change in stand. Once they realized that the very foundation of the plaint gets taken away with an existing, subsisting, valid marriage, they changed their case to being a concubine. And that was their written notes of arguments.
Yes.
And the learned court below proceeded on that basis. And then it's come forward and argued that because the learned court below is not here, I'll point out from the plaint 4 paragraphs. Kindly have a look at plaint. Page 1 is the plaint. But I'll give a brief outline of my case and then take your lordship through the otherwise of the points that I intend to argue. One is that 711 can be suo motu exercised by court.
That he has not.
He has not argued because we've learned the law from him. He knows that it can be done.
We are happy to learn that he is having such respect in court.
No.
Yes.
He didn't expect he was lawyer.
Yes.
No, without him, Mr. Basu. That.
Then you ought not to have started with that ball. Yes.
First, if that is there, then court under 711 can look at and nip in the bud when there is suppression of fact, and I'll make good these submissions with judgments, my lord. When there is suppression of fact, when there is abuse of process of law,
yes,
when it's an illusory cause of action, when the foundation of the plaint ceases to exist.
Which is your next point?
Next is, my lord, that a marriage under section
Special Marriage Act
is a void marriage. It's a void marriage. A marriage which is void is a marriage which never existed in law. No rights can be culled out from a marriage that is declared to be void. The law does not recognize a marriage. Requirement of it to be declared as a nullity is a complete different requirement of law. There's a latest 2021 Supreme Court judgment. I'll cite that. But what is void? That can't be the basis of a subsistence of an assertion of a legal right.
Yes.
Third, my lord, and this is important, that admitted facts need not be proved. Now, keeping the third point in mind, your lordship will just have a look at a couple of pages, my lord. First, the foundation of her case. Page 1 is the plaint. Lordship will have a look at paragraph 2. Oh, my lord, one more. I'm sorry. An argument was advanced that the court has prima facie come to a conclusion that is not maintainable. Then how could the court thereafter return a finding that is not maintainable? How could you pass a final judgment after you are prima facie of the opinion that the suit is not maintainable? The requirement of the law is prima facie only under 711. I'll show that. Because he has underlying documents which becomes the foundation of his plaint case. Prima facie, if that gives an illusory cause of action, then it's no more, then it becomes an obligation of the court to exercise power under 711 and nip such a suit in the bud.
Yes.
Now, paragraph 2. Plaintiff was married, paragraph 2, my lord. Plaintiff was married to one Rana Safui on September 25th, 2013 under the Special Marriage Act. Foundational fact 1. Paragraph 15, after that suddenly died. Paragraph 15, my lord.
Yes.
The said deceased had previously married Konika. This is my mother. But the relationship between the said deceased and the said lady became not only acrimonious but bitter to the extreme, which was amongst others causes of divorce alluded to herein above. So first, that she is married. Second, that there is a divorce to get out of 4. Now, paragraph 30. The substratum of her claim.
Yes.
The plaintiff as an paragraph 30, just the first sentence. The plaintiff as an intestate heiress is entitled to the proceeds of the amount. So marriage, divorced wife, therefore mine is valid. And claim for partition, intestate heiress, so 1/4. And then the prayers, where also your lordship will find the same thing at 23. Partition
23.
Page 23.
Page 20.
Page 23.
Which paragraph?
Prayers.
Prayer.
Yes. Partition of all the properties left behind by the deceased, including those mentioned in disregard this. 30 is one such paragraph I showed. And the plaintiff being the absolute owner of 1/4 share in each of them. So this is her plaint suit for partition on the basis of ownership that she is the legally married wife of my father. And how not just married wife, but a legally married wife? Because there is a divorce. Now, the injunction application, we got out all documents to show as an opposition that this entire case that she had made out in the injunction application was a false case. Now, how does she deal with that? Just paragraphs allow me to indicate. Kindly makes a few notes of a few dates. The appellant was married, according to her, on 25.
It was a list of dates.
I'll give a list of dates. But for your lordship's convenience now, I'll just indicate it. I'll give a list of dates. Just 4 dates will be relevant.
The initial interim order which was passed, you're showing us?
No. I'm just showing your lordship that the date of her alleged marriage.
Yes.
These 4 dates, if your lordship could just make a note of note. Otherwise, I'll just file a short list of dates.
Yes.
Ex parte decree of divorce between my parents was 1st March 2007. Divorce.
So ex parte decree of divorce involving Konika, your mother.
my mother and my deceased father.
Next.
1st March 2000. Next, decree set 12/9/2011.
Okay. 1st March 2000.
7 is the ex parte decree.
7. 2000.
12/9/2011 is the recalling of that ex parte decree.
So decree set aside.
This will be set aside.
On what basis?
Well, that order is at page 456. I'll take your lordship through that. 913, I think, because we were not represented. I haven't checked that note. I'll check the reasoning. I'll show that to your lordship.
Yes.
It's there on record. The appellant was married on 25/9/2013. So admission, I'm sorry, my lord, admittedly during the subsistence of the first marriage. Now, with regard to this, how does she deal with it? Kindly have a look at page 164 once of the paper book. Was not dissolved by reason of the fact that the ex parte decree for divorce that was shown to me by Rana was recalled on September 12, 2011. In the facts as narrated above, if the court records as produced by the defendants in the said application before the Honorable Court below, High Court are found to be genuine, then it would prove that fraud has been perpetrated by Rana Safoi on me by declaring to the society at large that I am the legally wedded wife of his. While in the hindsight, participating in the divorce proceeding against his first wife, Konika, even after our marriage in 2013. So it would prove that fraud. So now she has admitted that the first marriage is a valid marriage. And if there is a valid marriage, then my father has practiced fraud on her. I don't know, I can't verify this from my father who is practicing fraud on whom now, because he's no more. It's very easy for someone who worked in the office to come forward and say that I am his legally married wife.
Yes. Next.
So therefore, my lord, two facts are admitted here. That she got married during the subsistence of the first. And if that be so, then she has no right here. Then she changes it to fraud has been practiced. Now, one more paragraph your lordship will see.
Yes.
173, paragraph 10.
Yes.
With reference to statements and allegations contained in paragraph 5L of the said affidavit, I deny that I had suppressed facts or filed the suit in a manner to mislead the learned court as alleged or at all. This is important, my lord. In fact, I say that the suit was filed, kindly make note of this, on the bona fide presumption of fact that the marriage with the first wife, Konika Safoi, was dissolved as represented by the said Rana Safoi. And accordingly, the partition was asked for, claiming 1/4 share in the share of the deceased. I have been advised to take appropriate steps for amending the plaint on subsequent discovery of facts, and I am as such taking steps as advised by my legal counsel. So clear acknowledgement of the fact.
What amendment of the plaint?
Nothing. So when the application came to be heard out, nothing was done. And amendment also that.
What is according to you that amendment is what for? For incorporating Konika?
No, they would have then possibly changed from what she has said, that fraud has been played on me. Whatever amendments could not have been an amendment in this suit because it would have changed the very nature and character of the suit itself. But here she writes that in the suit, I had filed the suit on the bona fide presumption of fact that I was 1/4. But now that these facts have come up to light, I want to amend the plaint. And no such amendment saw the light of the day. So whatever that amendment, not going by the tenor of this paragraph, and which is why, my lord, during course of arguments in written notes, they changed tact and went to a concubine. So the very basis of the suit, that she is 1/4 heiress as a legally wedded wife, she gave it up herself. An admitted position today from these paragraphs.
Yes.
So only thing that I want to refer to here is that admitted facts in terms of section 58 of the Evidence Act need not be proved.
Yes.
So there is no point. And there has been serious repeated deprecation by the Supreme Courts and passed by your lordships also, that stop pushing suits to trial which anyways will not yield any result.
That you have said, Mr. Banerjee.
Yes,
Don't
Manoj, so-
repeat, we have taken into account.
No.
Yes. Yes.
So thereafter she goes on to admit that
Mr. Banerjee, these are facts which will certainly point out. What is your reply to the first point, that you see only the pleadings in the plaint?
Pleadings, yes.
Only what I have said in the plaint, that I am a legally married wife of particular person.
Well, the law now.
What you are showing us is that you are also drawing our attention to many documents which certainly would have to be taken into consideration. As regards his first argument, as regards his non-sustenance of the order under Order 711, what is your answer?
Well, the answer is now what has been consistently being held by.
That then you take,
Very well.
because Order 7 Rule 11, the principles are earmarked.
Correct.
And your contention is that it's a frivolous claim or a fraudulent claim. It has to be nipped at the bud. That is your argument.
Well, this is
satisfy us on that issue first, then required go into others.
yes. Well, so if I can show, because that's been the test. Yes, Manoj, because that's a hurdle that even I had to cross while getting ready. That how does the court today travel beyond the pleadings in the plaint?
Exactly.
And I found that there are two sets or areas of judgment which has now come about. On this point, if it's an illusory cause of action, if it's an abuse of process of law, or that if there's no point keeping it pending because the foundation of the plaint is gone, then it will be nipped at the bud and it's an obligation cast on the court by the court itself. I'll back these three things up with judgments of the Supreme Court. That if it's a product of clever drafting, if it creates an illusory cause of action, if nothing is being made out and the court finds that this is not going to succeed.
No, just one thing, because the very foundation of the case in the plaint was what? That I am the legally married wife of the deceased.
Which she herself.
Which you very strenuously argue that is not a fact, considered the aspects of this.
I have not shown to your lordship any document of mine. I am therefore only restricting it to the admission made by the plaintiff herself.
Where? Which admission? In the plaint?
Made in
the reply on affidavit or note.
That is a separate document.
Yes,
plaint.
No, not in the plaint. Not in the plaint. But admission, this is not my document. I am showing to your lordship an admission made by the plaintiff on oath before the court, saying my basis in the suit is now today gone. So what will the courts then do?
That we have to travel to the pleadings in the other applications and documents. We are.
Well, I'm not taking a lordship through to any other document.
From the plaint you show?
No, not just from the plaint. I'm saying, well, may I just first show these
So we
judgments?
understood your argument that the very foundational fact is wrong. Why should you allow this?
Not just wrong, but to show that this is wrong, I don't invite your lordship anything from the written statement.
Yes, what you are showing?
I am showing to your lordship a statement made on oath by the plaintiff herself.
Where?
What I just read out. This was the plaintiff's own.
The affidavit in reply.
Correct, her affidavit. It's the plaintiff's own stand. It is the plaintiff's stand apropos her own suit that I had filed it on a. Well, this hyper-technical approach that the appellant has argued before your lordship today has changed.
Exactly. We want to show that authority.
Very.
Satisfy us.
I'll start with that. I'll start with that.
This you are nipping at the bud. He has just started. He has just started.
A long bag nipped in the bud. My lord was with me.
No, Mr. Banerjee, give us the citation.
But
of the
to me
judgment so
But
that-
I'll place it in my own way. Not 2-3 paragraphs I haven't seen.
You just give us the citation.
Just citation.
You thereafter you place. Give us the citation.
2 judgments your lordship will kindly make a note of.
Yes.
This is 2011 8 SCC 249. And 2019 14 SCC 646.
SCC page.
I'm sorry, Milan.
346.
Of 2019.
346.
646.
646.
This
And these are the 2 judgments. Any other judgment?
No, the rest I'll look at the paragraphs and I'll come. Your lordship keeps it on any day. These your lordship will see that in abuse of process of law, it's been held that you have to apply 711.
I've never disputed. Without application, court suo motu can apply order 711.
No, my lord, then your lordships will today.
এখানেই থাক।
আর today না? Tomorrow.
Mr. ঘোষ আমাদের বন্দি করছে ও আমাদের উদ্ধার করতে পারে কিনা দেখি
ওটা জসে উঠে গেছে বরকন আসি ওট
Well, actually, your lordship pleasure would